Yes. Yes.
Number 509.
We're not upgrading. Mention before the next second. We can't.
Mullards,
Yes. Upgrade is.
Mullards, may I mention item
Yes.
125, Mullards? Mullards, we are seeking, I appear for the appellant. I'm seeking short accommodation to prepare the paper book, Mullards. Item 125.
Still require a direction for preparation of paper books. You'll only require a direction.
I have the direction, Mullards. I'm just seeking some more time.
So what should be done then? I mean, when it is taken up and then you mention.
Mullards, I'm seeking some short accommodation to prepare the paper book. Just Mullards, it's been listed.
Well, it appears to be mentioned. It will appear to be mentioned tomorrow then, for extension of the time.
May I be permitted to mention, my lord, item number
Grateful,
55?
To be mentioned what?
My lord, may I be permitted to mention, my lord, item number 55, my lord?
55 years.
My lord, I am praying for
Yes.
my lord, upgradation measure, my lord, urgency is there, my lord. My lord, railway authorities, my lord, without any acquisition, my lord, my land has been, my lord, under in position, my lord. And my lord, by
The last day we will not. On the last day we are not keeping any matter, urgent matter. Mention before the next circuit. Should have mentioned earlier then.
My lord, may I mention item 53, my lord?
53 years.
My lord, my only humble request, my lord, I am not praying for upgradation, my lord. My only humble request is to, my lord, condone the delay in filing of the appeal, my lord. If that can be
Mr. Shah,
taken.
whenever it is taken up, it will be done by whichever bench.
My lord, if that much can be done, my lord, that my lord,
Whenever it's taken up, that will be done. Not now. Yes.
grateful.
Yes. Call on the list.
For judgment, item number 1.
Accordingly, CRA 36 of 2021 is dismissed on contest without any orders to cause, thereby affirming the impugned judgment dated such and such. CRAN is also disposed of. Urgent certificate copy. Sorry, Mr.
Item number 2.
Yes, my lord. This is for correction, my lord.
What is the correction, sir?
My lord, my lord was pleased to ask me to make corrections
Yes,
in the
yes.
order sheet, my lord. Instead, my lord, I didn't dare to commit the sin. I have written it on a piece of paper, my lord. I have typed it. And the amount, I have written the amount, thereafter I striked it off. So my lord may put any amount of PR bond, my lord. And there is another correction at the top, my lord. An application for suspension of sentence instead of admission of
In the order dated June 16, 2026, comma, the following corrections are required to be incorporated. Colon, niche Roman 1. In the caption, comma, instead of an application for admission of appeal under section 374 within bracket 2 of the Code of Criminal Procedure 1973, comma, the caption will read as an application for suspension of sentence during pendency of the appeal. Roman 2, after paragraph number 23, the following will be incorporated. Colon দিয়ে নিচে para 24 number দিয়ে we direct that the appellant petitioner be released on bail upon furnishing a personal recognizance bond within bracket PR bond to the satisfaction of the learned sessions judge Kuch Behar. The parties are directed to act on the basis of server copy of the order. Let the order dated June 16, 2026 stand corrected accordingly.
Always.
অর্ডারের কপিটা ফেরত দিন, কারেকশনের পেপারটা রেখে দিন, ওইটা ফেরত দিন, পরে গুলিয়ে যাবে তাহলে মনে হবে। Mr. Biswas, just take back the order copy. Yes.
Item number 3.
And item number 3, Mr. Papi Sarkar is.
You want to withdraw it?
Yes, my lord. Matter has
Any
been
application is
amicably
also
settled
pending?
between the parties.
No application is pending.
No, my lord.
Very well. On instruction, learned counsel for the appellant submits that the appellant seeks to withdraw the appeal, full stop accordingly. FAT 32 of 2024 is dismissed as withdrawn without any order as to costs. Full stop interim order if any stands vacated.
Grateful to your lords.
Item number 4.
And
Four, I
item
appeal
number-
for respondent numbers 1 and 9.
There is an office report, we'll
Wait
just
for the
check.
appeal in- Yes. Office report.
You should-
Office report. You open that.
Records have been received, but there are certain defects.
My lord, probably when at the time of inspection, my lord, we went to the our department, my lord, they have said that one of the document has not been exhibited by that court below, my lord.
Not exhibiting the document, we cannot, that's not a defect. If it is not exhibited, it's not exhibited.
Probably that defect has been
We'll direct the office to give further particulars of the defect. The office shall furnish a revised report as to the exact particulars of the defects found in the trial court records at the earliest. Paper books have not been prepared due to that, probably.
Yes, my lord.
Yes, my lord.
Item number 5.
Lordship, I appear. on
Withdrawal?
withdrawal.
Any application is pending?
No, Your Lordship, the
appeal
stay
yes.
was there for the mat appeal.
So can also has to be dismissed as very well.
My lord, I am for
Lordship,
the
I have
respondent.
instructions on record.
Right.
I am for the
Learned
respondent.
counsel, yes, learned counsel for the learned counsel for the appellant submits on instruction that the appellant does not want to proceed further with the appeal and to withdraw the same. So accordingly, MAT 51 of 2026 and CAN 1 of 2026 are dismissed as withdrawn without any order as to costs. There are no interim orders passed.
No, Lordship, one
no,
indulgence.
Written instruction filed today,
Yes.
be kept on record.
Lordship, they have asked to mention, if possible, that the consequent legal remedies may be pursued if that liberty would have been given by the honorable.
What is the legal remedy?
Lordship, they preferred a writ petition before it was decided on merits. So as per the Honorable Supreme Court's judgment, they want to pursue the Supreme Court because it was decided that trial should have
আচ্ছা
been
যেখানে বললাম
executed.
withdraw dismiss as withdrawn, we are granting with leave to pursue the appropriate remedy, Mr. Boni.
Yes, Your Lordship.
You are for the
Yes,
answer.
Yes. Number 4. Lordship.
যেখানে dismiss as withdrawn with liberty to pursue the appropriate legal remedy, comma, if available.
Grateful, Your Lordship.
Grateful.
Thank you.
Item number 6.
6, my lord, I appear for the state. I'm sorry, my lord, yesterday I missed the list. I was not present. Mandamus appeal, my lord.
Anurag Sharma, it's a short pass away. He's just coming.
Who?
Anurag Sharma.
You are also there?
No, I am not.
Pass over.
Yes.
Pass over. Next.
Item number 7.
7, my lord, for respondent Mr. Navankur Pal is appearing, my lord, short passover, my lord.
Short pass, if we call on the
appearing, my
specially
lord,
fixed
he's
matters,
on
then
this.
we won't be able to take up any other matter. Passover means nothing. Every matter cannot be passed over.
Short passover, my
No,
lord.
who is for the appellant? You are for the
No, no, I'm
appellant.
for the
What is the
appellant.
matter?
I'm led by senior advocate Mr. Amlesh Shah. He's up in.
Yes, Mr. Rai, where is Mr. Rai?
My lord, I'm praying for a short Passover, my lord. Just-
Passover.
Passover, sir.
Item number 8.
My lord. And for the,
Just in a nutshell, Mr.
yes.
Yes.
But should I
Mr.
give a
Bishop,
back-
please take your seat, both of you. I mean,
Should I give a background of the case?
yes,
One.
yes.
CW1 happens to be the brother of the deceased who lodged the complaint, my lord. he says in his deposition,
What is this 302?
302,
Life. You've got life.
life. So he says that the accused person called his wife over phone outside the house, and after 40 minutes, a phone call came in the phone of the mother-in-law, and he said that he has killed his wife, and they went running to the banana garden where the wife was found dead. This is the case. And thereafter, in his deposition, he also says, my lord, your lordship has asked a query, my lord, that who came home first, my lord. In that regard, my lord, in the cross-examination of PW1, he has clearly stated that my mother informed me what she heard on her mobile. By that time, my father had also returned home from the market. That's in page 11, line from the last line, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 10th line. By that time, my father has also returned home from the market. So as per him, he and his mother was before, and thereafter the father entered. Thereafter, my lord, the PW2, who happens to be the mother-in-law, she says that my son returned, and the children was also there, and the children told her son that both the parents are outside the house. And thereafter, after some time, a phone call came in her mobile. She handed over the phone to the father-in-law. To the father-in-law, the accused person confessed that he has killed his wife, and thereafter they running towards the banana garden and found the dead body of the victim, my lord, and the deceased, my lord.
Who was PW2? Who was PW?
Mother-in-law.
Very well.
So because the PW1 says he called the mother-in-law, mother-in-law heard. Mother-in-law says the father-in-law heard over phone. Now the father-in-law says when he returned home, the children was there. The younger child told him that the younger child told him that the father has beaten up the elder son, and the elder son thereafter stated that the parents were trying to go backside of the house. He tried to accompany them. The father hit the elder son, and thereafter he was crying. Thereafter he called the accused person, and he gave some signs. And thereafter suddenly a phone call came in the mother's mobile, and the mother. To the mother, the accused person confessed that he has killed, and thereafter she went running back to the banana garden. So thereafter there are witnesses, my lord, who has stated that they heard some sounds, and thereafter they went to the banana garden, and they found the dead body, my lord, and they do not know anything about what has happened with regard to the incident. So PW5 also gives the same thing. They do not know how and what happened, my lord. 5, 6, they give the same depositions, my lord. Even 7 says the same thing, my lord. And he says that he says that subsequently we came to know the sister of Pankaj died, and he says that when I reached the house, there were already 25 to 30 people in his cross. They're the PW7, my lord. They are not vital witnesses. The most vital witness in this case is PW9, my lord. I will just read the statement of PW9. That is happens to be the child witness, because in the judgment, my lord, the judge has relied on that statement and has given the conviction based on last seen together theory as well as the confession.
What was the relation of the child with the deceased?
Father, mother.
What was the age of the child?
10.
Male. Which page?
Page 23.
7.
Yes.
7. The age of the child was 7.
7.
10 children?
Plus 2.
Yes.
Is it about 12 years it's written?
Jokon deposition. When he is giving the deposition.
Oh, yes.
And there is also 164 statement of this child. That also I will go through, my lord. So he says, my lord, I am a student of class 6. Today I have come to depose in this case. And thereafter, the court comes to the conclusion that I tested the witness and he's able to give rational answer to my question, and he's able to understand question and able to give rational answer to my question. The complainant, Paresh Bormon, is my grandfather, and he had filed this case against my father, Shochindra Bormon. So he is present today in the courtroom. The incident took place at about 3 years ago in the evening, just behind my grandmother's house at Kodal Kheti.
Paresh Bormon was the maternal grandfather.
Yes. The incident happened in the
house of the in-laws.
in-laws.
Right.
At the relevant time, I, along with my 2 younger brothers, were studying at the veranda of my grandfather's house. At that time, my mother told my father that she wanted to make a telephone call to my uncle Pisha and asked for cell phone from my father. My father told my mother to go behind the house and he would connect the phone to Pisha. My mother and father went behind my grandfather's house, and I also followed them silently. And my younger brother told this fact to my father. Then my father assaulted me on my right eye, and I returned to the veranda and started reading. Thereafter, my father returned from the market and asked us, where were our parents? And at that time, I was crying. Then my younger brother told my grandfather that my parents were behind the house. My grandmother also came after some time and asked us where were our parents. And at time, my younger brother told my grandmother that my parents were behind the house. At that time, my grandmother received a phone call, and my father told from the other side to hand over the phone to my grandfather. Then my father told my grandfather that he had killed my mother at the banana kola bagan behind the house, and he also took poison. Then the cell phone dropped from the hand of my grandfather, and my grandmother took the phone. And then I, along with my grandmother, went to the kola bagan, and I saw that my mother was lying dead. I noticed that my mother's mouth was filled with clothes, and the stem of the tree was put inside her nose of my mother. I looked around and I did not see anyone else around. Then the local people came to the spot and took the dead body of my mother to the house. One person told my mother was still breathing, and he was looking for my father. And my father was found in the bathroom who had consumed poison. Then both my father and mother were taken to Nishiganj hospital, and it was detected that my father had consumed alcohol and not the poison. Then after examination, the doctor declared my mother dead. During investigation, police produced me before the learned magistrate, and my statement was recorded under section 164. And this is the said statement recorded by the learned magistrate, which is marked exhibit 3. And these are my signature, which are marked as exhibit 3/1. Now the cross-examination, my lord. I cannot say my date of birth. At the relevant time, I was studying in class 3. And at that time, I was 7 years old. My father's house is situated at Purbo Unishbisha, and we used to reside in the same house. 2 days prior to the incident, we had come to the house of our grandfather. After coming to the house of my grandfather, there was no quarrel between my father and mother. But in the past, they used to quarrel. About 10 to 12 days prior to the incident, there was a quarrel between my father and mother, and thereafter they were living normally. I did not state anything to the police about the incident. I was produced before the learned magistrate after 2 to 3 months of the incident. My grandfather told me that I should go before the learned magistrate. It is not a fact that I was tutored by my grandfather what to tell before the learned magistrate. I was accompanied by my grandfather and grandmother when I was brought before the learned magistrate. I was residing in the house of my grandfather between the date of incident and the date of my recording of statement. And at present, I have been residing with my grandfather. And today also, I have come to the court with my grandfather. I did not state before the learned magistrate 164 CRPC that I was studying in class 2. At the relevant time, there was 2 rooms in my grandfather's house. One is situated on the western side, another was on the northern side. We were studying on the veranda on the western side. The kola bagan is situated 15 to 20 hands from the house, and the area of kola bagan is about 1 bigha. My grandfather and grandmother were not at home when my mother and father went to kola bagan behind the house. My grandfather and grandmother did not go to kola bagan till they received the phone call from my father regarding the incident. I cannot recall it whether I have stated before the learned magistrate under section 164 CRPC that my mother told my father that she wanted to make a telephone call to my uncle Pisha and asked for cell phone from my father. I have stated before the learned magistrate under section 164 CRPC that my father told my mother to go behind the house and he would connect the phone to Pisha. When my grandmother received the phone call, we were reading on the veranda, western side room, and when she received the phone, she was on the courtyard and my grandfather was also there. I did not hear what my father told to my grandmother and grandfather over telephone. I raised hue and cry when I saw the body of my mother at Kolabagan and about 50 to 60% assembled at the Kolabagan. On one Raju, Bappa and another Dadu brought the dead body of my mother to the house from Kolabagan. I had stated before the magistrate once that my father was found in the bathroom. I came to know from the doctor of the hospital that my father did not consume poison, but he consumed alcohol. I did not go to the hospital, nor I met the doctor in the hospital. It is not a fact that my mother did not tell my father that she wanted to make a telephone call to my Pisha and did not ask for cell phone from my father. It is not a fact that my father did not tell my mother to go behind the house and he would connect the phone to Pisha. And thereafter, not a matter fact. I'm not going on. It's all not a
Instead of
fact.
reading the entire thing, just point out what are the discrepancies as per you.
Yes, yes. Well, I will just go through the 164. That is very, very, very important. This child, my lord, he has been tutored. Why do I say so? Because in his deposition, he has focused on last thing together. And in his 164, he has focused on the confession. Why do I say so? My lord, I'll say now. Very often, my father...
Which page?
Acha, this is an extra. This is a extra page which has...
Extrajudicial copy.
Extrajudicial copy.
It is there. It is already there.
It's there. It had been handed over.
It is there.
আছে আচ্ছা তাহলে এটা ফেরত দিয়ে দিন ওনাকে মিশামিশাকে মাল্টিপল কপি হয়ে গেলে প্রবলেম হবে What was the name of the child?
Child is Jointo Bormon.
Yes, very well.
My lord.
Page.
I'm reading, my lord.
Yes.
Very often, my father, Shochindra Bormon, had an intense quarrel with my mother, Shobita Bormon, who had died. On
No,
the
no.
day of incident, my grandmother...
Joyanto Bormon is the son.
Son.
Achha, next page. Next. Thanks.
Second page.
Yes. Yes, carry on. Very
On
often.
the day of incident, my grandmother went to shop for bringing sugar. My grandfather went to market. Then my mother spread over a choti mat for sitting for me and my younger brother Povitro. And at that time, my father was talking over phone using headphone to somebody. Then I and my mother wanted to know from my father what he was saying. After that, my mother told to my father to change the SIM of the phone. And then my father answered, no. My mother said she would throw away the phone. Father replied, see what I do after that. Then my father said to my mother that if my maternal uncle comes, she should not disclose anything to him in this regard. After that, when my father took my mother towards the backside of the house, I went to see on the slide. Then as my younger brother told my father about this, my father assaulted me near the eye and knocked me down. Thereafter, he said to me angrily, don't disclose anything to anybody, keep silent. Then my father was roaming about silently for 5 to 6 times from the side of the courtyard of the house where my mother was sitting and which was situated beside the room of my maternal uncle to the doorstep. This was not stated, my lord. This line was suppressed, firstly, which says that the father was roaming in the courtyard and he tried to portray in his deposition that the father went along with the mother to the backside of the house, firstly. Secondly, my lord, he says that his father told to the mother that you go to the backside of the house and I will connect the phone to Pisha. This was never stated in his deposition.
Is there a sketch map of the place of occurrence? Is there a sketch map of the place of occurrence? We'll come to that later.
Yes,
You
yes,
complete
I'll
this?
come.
Yes.
Then my father was roaming about silently. Thereafter, my grandfather came at first and asked me, where are the member of the house? Then as I remained silent, my younger brother told my grandfather that father and mother are on one side of the courtyard and father had assaulted my elder brother. Now he says they are in one side of the courtyard. Then my grandfather took my younger brother in his lap. And then when my grandmother came, he took my younger brother in her lap. Then a phone call came to my grandmother. And when my grandmother received the phone call, my father told her to hand over the phone to grandfather and said to my grandfather, "Father, I am telling you words. I have killed your daughter beside the banana tree and left her there. And I consumed poison and don't know as to what to do." Then I, along with my grandmother, went beside the courtyard of the house, and I first saw that my mother was lying dead beside the banana tree. And that is totally false. Why? The dead body of the mother was found in the banana garden, not beside the courtyard, beside the banana tree. It was never found. After going, I saw that the mouth of my mother was filled with clothes, and stem of the tree was put inside the nose of my mother, and blood was oozing out of the mouth and nose of my mother, and the bone above the neck had been broken by dragging. These things are not to be found in even the post-mortem report or in the inquest with regard to the fact that blood was oozing out of the mouth or nose. And then a phone came to the mobile of my grandfather saying that my father has consumed poison, and I was lying beside the latrine, and that he should be taken to hospital. Then one person said that my mother was inhaling. She should be taken to hospital. Then when my mother was taken to hospital by car, the doctor declared my mother dead, but my father was well beside the latrine. After that, when my father was being taken by the car, my father said in my presence that he himself with his own hands strangulated my mother, Shobita, to death. My father did not consume poison. He drank alcohol with water to kill my mother. My father used one mobile and many SIMs. I saw this secretly. So he was tutored to such an extent, and he has never said this all thing in his deposition. And his father was in the courtyard itself. He gives an alibi to the fact. And the PO, my lord.
And he
is in
says that he saw the mother and father together. Place was different. Courtyard.
Courtyard.
The fact remains that he saw his parents together.
No, my lord. The thing is that, first and foremost, this thing of this last seen together theory has to be stated in the FIR. That is very important. Why I will say why. Because this is the fact based on which they are trying to implicate the father. This is a material fact which is required to be there in the FIR, also to be stated by the PW1. The prosecution has slowly developed the story in order to implicate the father with regard to the last seen together theory when they saw that the confession was not
Working.
Yes. Because there was contradictory story. Therefore, they started developing the story in that manner. Now, my lord, the PO is in page number 6. The sketch mat of the PO. And it shows the house was 20 meters away from the banana garden. Page number 6.
Is there a legend?
Written is page number 7. B, bracketed distance between A and B is about 20 meters. And thereafter, the banana garden starts, and where the dead body was found, it is nowhere stated in the banana garden because it was a 1 bigha land. They only said banana garden.
Courtyard appears to be adjacent to the banana garden.
No, it's not adjacent, it's 20 meter away. Onek distance, 20 meter. Thereafter, the banana garden starts. Now, my lord, I will just show some relevant portion of the judgments on which the conviction has been given, man. It starts, the relevant portion of the judgment starts from 50, page number 50.
Yes.
It says in the middle, my lord, I have gone through the entire material on record. The main allegation against the accused is that on the date of the incident, he took his wife to a banana field just behind his in-laws' house and throttled her to death. There is no doubt that the disease was murder and the death was due to the effect of throttling, which was antemortem and homicidal in nature, and none of the witness, including the PW9 witness of the Master Jayanto Barmun, witnessed the incident of the murder of the disease by the accused. So he says that there is no direct evidence. However, other oral and documentary evidence produced by the prosecution shows a chain of circumstantial evidence which points finger towards the guilt of the accused person. Now, the question arises whether the prosecution has been able to establish complete chain of circumstances by which conclusion of guilt would be drawn against the accused. Thereafter, he says that in the instant case, I don't want to read so much. Thereafter, the relevant portion is moreover the PW9, Master Jayanto Barmun. It starts in the middle.
Seen the victim in the company of the accused.
Who is the minor, yes, has last seen the victim in the company of the accused before death, and as per section 106 of the evidence, the burden of proving the cause of death lies upon the accused on the actual fact regarding the death of the deceased is within the special knowledge of the accused. There is nothing to show that the presence of any other person except the accused. Moreover, the medical evidence of PW11, who conducted the postmortem over the dead body, shows that the death was due to asphyxia caused by strangulation along with throttling, and the death was antemortem and homicidal in nature.
Ms. Sarkar, was there any defense witness in this case?
No, not required, my lord.
No, we are not saying required or not. We are asking you. And 313 is also there. We'll look to
Has
that.
to be there. Another. So he relied on 106 firstly, and thereafter, should I page 54 with regard to motive, what he says. 54 in AIR 2000 SC 1735. The Honorable Apex Court has observed that motive is a relevant fact in all criminal case, whether based on the testimony of eyewitness or circumstantial evidence. The question in this regard is whether the prosecution must fail because it failed to prove the motive, or even whether inability to prove motive would weaken the prosecution case. No doubt, if the prosecution proves the existence of motive, it would be well and good for it, particularly in a case depending on circumstantial evidence, for such motive could then be counted on as one of the circumstances. However, it cannot be forgotten that it is generally a difficult area for any prosecution to bring on record what was in the mind of the accused. Even if the IO would have succeeded in knowing it through interrogation, that it cannot be put in evidence by them due to the ban imposed by law. Thereafter, he says, I'm reading the relevant portion only. In the instant case, also the prosecution has not produced any evidence, my lord, the last line, second last line. In the instant case, also the prosecution had not produced any evidence to prove the motive behind the evidence which points finger towards the accused person behind the murder of the victim. The prosecution has produced evidence to prove that the victim was last seen together in the company of the accused, and immediately thereafter her dead body was found in a banana garden, and no explanation is offered by the accused as to why the victim died. Moreover, the postmortem report shows the victim was throttled to death and death was homicidal in nature. All this evidence shows sufficient circumstantial evidence which points finger towards the guilt of the accused. Therefore, in the instant case, when there is sufficient circumstantial evidence to prove the guilt of the accused, the absence of motive does not make entire prosecution case untrustworthy and unreliable. Thereafter, page 56, my lord. The relevant portion. On going through the written complaint, 56. On going through the written complaint, I find that on the date of incident, the accused called the deceased from her mother's house on the pretext of roaming around and took her outside the house. But in his evidence, the PW1 has deposed that the accused called the deceased over her mobile phone and asked her to visit nearby place, and accordingly, the deceased went there. So there is a minor contradiction in the evidence of PW1. And the contents of the written complaint as to how the deceased was called by the accused, whether over telephone or personally, this particular contradiction pointed out by the learned defense counsel is so minor that it would not touch the very root of the prosecution case. But the fact remains that the accused had taken the deceased behind the house of the complainant, and immediately thereafter her dead body was found in the banana field. Thereafter, page 57. Considering the evidence of PW 1, 2, 3, it is evident that a phone call had been made by the accused and he had informed that he had killed the victim behind the house. But there is some contradiction as to whom he had actually informed about the murder of the deceased, whether it was to the PW1 or PW3. It is an admitted fact that neither the PW1 nor PW2 nor PW3 had seen the incident of murder, nor they have seen the accused and the victim together prior to the incident. The police has also neither seized the cell phone during investigation, nor they had produced the call details of their cell phone during trial. However, this court does not want to give much importance to the contradiction pointed out by the learned defense counsel regarding the phone calls alleged to have been made by the accused regarding death of the victim, as the prosecution case is not based on the evidence of PW 1, 2, 3, but the entire prosecution case is based on the theory of last seen together given by PW 9. So the contradiction pointed out by the learned defense counsel regarding the information of murder given by the accused to the cell phone of PW 2 and 3 appears to be irrelevant in the instant case. Moreover, it is settled by decisions of Apex Court that there is bound to be some discrepancy between the narration of different witnesses when they speak on details, and unless the contradiction are of material dimension, the same should not be used to jettison the evidence in its entirety. Incidentally, the corroboration of evidence with mathematical necessities cannot be expected in a criminal case. And the judge also, the learned trial court also relies on the 164 statement. In that regard, in page number 61, he says, page 61. May I, my lord?
Yes, yes.
He has given, my lord, he has given every detail of the incident. It is,
Yes.
my lord, found, my lord.
Found.
He has given every detail of the incident which occurred on that particular day, and his substantive evidence given before the court and his statement under 164 CRPC corroborates each other regarding every detail of the incident, especially that he has seen the victim and the accused going together behind the house. Even after through cross-examination by the learned defense counsel, his evidence could not be demolished on material point. So on a careful evaluation, the evidence given by PW9, I do not find any disbelief. The evidence of PW9, who is a child witness. And thereafter, with regard to 164, page number 63, again, he relies on that and he says, so the statement made by the PW9 before 63. So the statement made by the PW before the learned magistrate under section 1 regarding the victim being last seen with the accused has been fully corroborated by substantive evidence given before the court, and the said statement under 164 has been exhibited and marked as exhibit 3 during trial. Since the statement made by PW has been exhibited during trial after complying with all legal formalities and the same has been fully corroborated by the substantive evidence PW9, this court do not find any legal hurdles to rely on the statement 1 regarding the last theory of last seen together. So I just read the relevant portion of the judgment. Now I will rely on certain judgments, my lord. First one is Kanhaiya versus State of Madhya Pradesh, my lord. Para 38, 40 and 58, I rely on. 38. May I, my lord?
Yes, yes.
The incident took place in a small village where everyone is known to each other. Punya was closely related to Ramesh. Thus, has he actually seen the incident, this fact was bound to crop up in the discussion among the family members, and in that event, the name of Punya as an eyewitness to the alleged assault would definitely have reflected in the FIR. It is true that the reason for the said material omission could not be elicited because the first informant Goboria turned hostile. However, the fact that the name of the family member who claimed to have seen the assault was not mentioned in the FIR is undoubtedly a very vital omission which would have a bearing on the veracity of the prosecution case. We may hasten to add here that Punya is not the scribe of the FIR, but the omission of his name in the FIR gains significance considering the fact that the incident started with the accused trying to damage the heart of Jagdiya, father of Punya. In this background, the omission of his name in the FIR is material one. Thus, we have no hesitation in the conclusion that Punya falls within the category of a wholly unreliable witness. Thereafter,
But this is premised on eyewitness.
yes,
Eyewitness not mentioned in FIR.
Yes,
That is
but-
a vital omission or
Yes,
fatal omission.
Yes, if the children have seen the parents going behind the house,
Here, nobody has seen. It's not the case of the prosecution that anybody saw. This judgment says, had he actually seen the incident, the fact was bound to crop up.
yes,
Next, another sentence. However, the fact that the name of a family member who claims to have seen the assault was not mentioned in the FIR. So, eyewitness was not mentioned in the FIR. It was not mentioned in the FIR in this judgment.
yes. So
That
over here,
somebody
the children,
saw. Here, nobody saw.
supposedly,
Therefore, how does it
if
become
the
relevant?
if the children saw their parents going behind the house, then why did the brother
No,
say?
that is conjectural. They never say that he saw the. Here, the commission of the crime was seen by an eyewitness. That is the premise of this judgment. An eyewitness to the assault, to the offense, was not mentioned in the FIR at all.
But the material fact
Here,
is,
there was no eyewitness in
but
your
the
case.
material fact is required to be written in the FIR. Supposedly, if they say that the child has seen the parents going
You
behind
know,
the house,
several times, FIR not an encyclopedia and
but
so on and
material
so
fact
forth.
is required to be written.
It's not a pleading. FIR is not a pleading.
Might be, but
Something happened, somebody lodges a complaint, the rudiments have to be there that a crime has been committed, the general location of the crime, this much. Entire witness's name should not be there. Here, eyewitness, somebody saw, one person saw, not mentioned in the FIR
but
at
the
all.
children saw the parents going behind.
Going
That is
behind is not the offense.
it is very important, my lord, because the child, he says that the father has beaten up the child. Those material facts was required to be written in the FIR by stating that the children was present in the house at the time when the mother went out. That fact was not written in the FIR, neither by the PW1, my lord. PW1 also doesn't state so.
All right.
And he is the first person who has given he has set the criminal law in motion, my lord. It is required, my lord. Then, my lord, para 58. In this regard, reference may be made to the decision of the court in Pankaj versus State of Rajasthan, wherein it was emphasized that when the genesis and the manner of the incident itself are doubtful, conviction cannot be sustained. The court held as under, it is a well-settled principle of law, then when the genesis and the manner of the incident is doubtful, the accused cannot be convicted. Inasmuch as the prosecution has failed to establish the circumstances in which the appellant was alleged to have fired at the deceased, the entire story deserved to be rejected. When the evidence produced by the prosecution had neither quality nor credibility, it would be unsafe to rest conviction upon such evidence. After having considered the matter thoughtfully, we find that the evidence on record in the case is not sufficient to bring home the guilt of the appellant. In such circumstances, the appellant is entitled to the benefit of doubt. And 59 also, my lord, that relevant portion.
Yes, we have seen the same
Yes, my
principle.
lord.
Same principle.
My lord.
Genesis and origin.
Yes, my lord. This is the one of the judgment I rely, my lord.
Mhm.
The second one is Shochin versus State of Maharashtra, para 12, 14 and 15.
Yes.
Evidence of PW2 Surendra, when compared with the evidence of PW6 Rajpal, who is cited as another eyewitness, reveals that there is a variance in the ocular testimony of both these witnesses. When PW6 Rajpal has deposed that on the day of incident, after hearing cries, he came in front of the house of deceased Pancham and saw accused assaulting deceased Pancham by wooden log and thereafter by stone, and thereafter deceased Pancham was taken to hospital. He attributes presence of PW2 Surendra. However, evidence of PW2 Surendra as aforesaid does not establish presence of PW6 Rajpal when incident of assault was in progress by wooden log, as according to PW2 Surendra, PW4 Yogesh and PW6 Rajpal arrived on the spot when the accused picked up stone and caused injury to the deceased Pancham. Even otherwise, PW2 Surendra admittedly is an interested witness, being nephew of the deceased Pancham, and PW6 Rajpal, though is an independent witness, his evidence is not convincing for the reason that his statement was recorded by police on 10/8/2013, that is on the 4th day of incident. Said fact that create doubt in the case of the prosecution of PW6 Rajpal witnessing the assault on deceased Pancham, as it has come in his evidence that on the following day of incident, he was called by police and in his presence, inquest Panchanama was drawn. And he has also proved this document as Exhibit 50. However, did not find it necessary to disclose about the incident to police immediately on the following day. Paragraph 14, my lord. In the light of above discussion, evidence of two eyewitnesses, we thus find it useful to refer to the decision in the case of state of Himachal Pradesh versus Gyan Chand, wherein the Honorable Apex Court, while considering the effect of delay in recording statement of the witness under section 161 of the CRPC, has observed as under, if the prosecution fails to satisfactorily explain the delay, and there is a possibility of embellishment in the prosecution version. Now, the FIR was lodged after 8 days of the FIR, the 164 statement was given by the child. And the cause for such delay was never explained by the prosecution in my case. If the prosecution fails to satisfactorily explain the delay and there is a possibility of embellishment in the prosecution version on account of such delay, the delay would be fatal to the prosecution. However, if the delay is explained to the satisfaction of the court, the delay cannot by itself be a ground for disbelieving and discarding entire prosecution case. The effect of delay was also considered by the Supreme Court in the matter of Dilawar Singh versus State of Delhi. In a criminal trial, one of the cardinal principles for the court is to look for plausible explanation for the delay in lodging the report. Delay sometimes affords opportunity to the complainant to make deliberation upon the complaint and to make embellishment or even make fabrication. Delay defeat the chance of the unsoiled and untarnished version of the case to be presented before the court at the earliest instance. That is why if there is a delay in either coming before the police or before the court always view the allegation with suspicion and look for satisfactory explanation. If no such satisfaction is formed, the delay is treated as fatal to the prosecution case. Third, my lord. It is the Firoz Khan, Akbar Khan versus State of Maharashtra. It's a live law judgment which I have given, my lord. It's a judgment of 2025. It is also relating to delay, my lord, para 21. It also says with, may I read, my lord? Insofar as the delay of 2 to 3 days in recording the statement of the eyewitness under 161 of the Code of Criminal Procedure 1973 is concerned, the said delay has been thoroughly explained by the witness, including the investigating officer, to the effect that there were riot in the area. On this score, the investigating officer was involved in maintaining law and order in the affected area. In the attendant fact and circumstance, course of action adopted by the police cannot be termed unjustified, and no adverse inference can be drawn on this account. No doubt that the court has laid down that an inordinate delay in recording witness statement can prove to be fatal for the prosecution, as pointed out by the three learned judge in Ganesh Bhavan Patel versus State of Maharashtra. However, therein, the delay in recording statement of the material witness was accompanied by a delay in registering of the FIR and the surrounding circumstances which led the court to hold that there was a cloud of suspicion on the credibility of the entire rap and woof of prosecution story. The court held in favor of the convict accused as the inordinate delay therein could not be sufficiently explained. Delay of about 27 days in a case where communal violence had broken out was held not fatal in Lal Bahadur Lal Bahadur versus State. Delay of over 2 years in recording witness statement was deemed as not fatal when explained. Delay in recording witness was held not fatal per se in Sunil Kumar versus State. Delay in recording statement of witness was held to be have cast serious doubt on the prosecution stories in version in Shahid Khan. It was held in Gautam Juardar versus State of West Bengal by a coordinate bench that there was some delay in recording the statement of the eyewitness concerned, but mere factum of delay by itself cannot result in rejecting in their testimony. Per our understanding, Ganesh Bhavan Patel is not an authority to contend that delay in recording witness is always fatal to the prosecution case. Thus, stricto sensu, delay in recording witness statement, more so when the said delay is explained, will not aid an accused. Of course, not hard and fast principle in this regard ought to be or can be laid down as delay if any recording statement will have to be examined by the court concerned in conjunction with the peculiar facts of the case before it. Our reading of the above shall apply on all fours to delay in the context of section 164 of the code. This delay will also be applying to 164 statements, my lord. Next judgment is State of Maharashtra versus Ahmed Sheikh Babajan and others. Para 26.
Yes.
Apart from the fact that lodging of information under section 154 CRPC keeps the DM, district magistrate, and the superintendent of police informed of the occurrence and when recorded, is the basis of the case set up by the informant and provides material to the police to commence investigation. Its fundamental object is that it acts as a safeguard against embellishment, exaggeration, and forgetfulness. True that it is not the requirement of law that every minute details of the occurrence need to be recorded in the first information report, and as observed by this court in State of AP versus Golconda Linga Swami, that the FIR is not intended to be an encyclopedia of the background scenario. Nevertheless, having regard to the fact that it is one of the modes by which a person aggrieved set the criminal law in motion, it must disclose the commission of an offense, though it is tried that the first information report does not constitute substantive evidence and can, strictly speaking, be only used as a previous statement for the purpose of either corroboration or contradiction its maker. Yet, omission of material facts pertaining to the crime is undoubtedly relevant in judging the veracity of prosecution case. My fifth judgment, my lord, Pradeep versus State of Haryana. This is with regard to child witness. I start with para 7. Para 7.
Yes.
We have carefully considered the submission. The fate of the case depends on the testimony of the minor witness Ajay. Under section 118 of the Evidence Act 1872, a child witness is competent to depose unless the court consider that he is prevented from understanding the question put to him or from giving rational answers by the reason of his tender age. As regards the administration of oath to a child, witness section 4 of the Oath Act 1969 is relevant.
How is this relevant, Ms. Sarkar? Here it was recorded by the court that he was able to give rational answers.
My lord, in his deposition, only 2 questions was asked. Nothing. I will come. That question is also described. What are the relevant questions? I'll go through this judgment, my lord, once. Under the provision of subsection 1 of section 4, it is laid down that in a case of child witness under 12 years of age, I'm reading the last para of page 6. Unless satisfaction as required by the said proviso is recorded, an oath cannot be administered to the child witness. In this case, in the deposition of PW1, Ajay, it is mentioned that his age is 12 years at the time of recording of evidence. Therefore, the provision of section 4 of the Oath Act will not apply in this case. However, in view of the requirement of section 118, the learned trial judge was under a duty to record his opinion that the child is able to understand the questions put to him and is able to give rational answers to the question put to him. The trial judge must also record his opinion that the child witness understand the duty of speaking the truth and state why he is of the opinion that the child understand the duty of speaking the truth. It is a well-settled principle that corroboration of testimony of the child witness is not a rule, but a measure of caution and prudence. A child witness of a tender age is easily susceptible to tutoring. However, that by itself is no ground to reject the evidence of a child witness. The court must make careful scrutiny of the evidence of a child witness. The court must apply its mind to the question whether there is a possibility of a child witness being tutored. Therefore, scrutiny of the evidence of a child witness is required to be made by the court with care and caution. Before recording evidence of a minor, it is the duty of the judicial officer to ask preliminary questions to him with a view to ascertain whether the minor can understand the question put to him and is in a position to give rational answer. The judge must be satisfied that the minor is able to understand the question, respond to them, and understand the importance of speaking the truth. Therefore, the role of a judge who records the evidence is very crucial. He has to make a proper preliminary examination of the minor by putting appropriate questions to ascertain whether the child is capable of understanding the question put to him and is able to give rational answers. It is advisable to record the preliminary questions and answers so that the appellant court can go into the correctness of the opinion of the trial court. Thereafter, the judgment further says what were the questions which were administered. In the fact of the case, the preliminary examination of the minor is very sketchy. Only 3 questions were put to the minor, on the basis of which the learned session judge came to the conclusion that the witness was capable of giving answer to each and every question. Therefore, the oath was administered to him. Following are the question put to him: in which school you are studying? What is the occupation of your father? Should one speak truth or false? We are of the view that the learned session judge has not done his duty. Nevertheless, we have carefully scrutinized the evidence of the minor witness Ajay. In his examination chief, he stated that on the night of 30th December 2002, the accused entered his house by breaking a window while the appellant held his mother by his hand. Accused number 1 assaulted her with a knife. When he tried to rescue his mother, accused number 1 gave a blow on his back by a knife. He stated that he was hiding in the house after the accused fled, and he disclosed the incident to milkman Surinder, who came to the house at 5 a.m. In the examination chief, he deposed about the incident of cutting of crops on their family land by the accused number 1 and 2, which had taken place 6 to 7 months prior to the date of offense. He stated that though the accused indulged in the said act, no action was taken as the appellant's father apologized. In the cross-examination, when the witness was confronted with his statement recorded by police, he admitted that this incident was not recorded therein. In the cross-examination, the witness volunteered the accused present in the court had murdered his mother and they were drunk. However, he accepted that the allegation that the accused was drunk was not recorded in his statement recorded by the police. Thereafter, para 16. Apart from the non-examination of the milkman, PW11 Mihir Singh, investigating officer, did not make any investigation by recording the statement of the elder brother of Ajay for verifying whether there were away from the house on the date of incident. In my case also, the younger brother was not made any prosecution witness. After closely scrutinizing the evidence of PW1, Ajay, and considering what we have already observed, the possibility of the witness being tutored cannot be ruled out. There is no support or corroboration to the testimony of PW1, Ajay, apart from other deficiencies in the prosecution case as pointed out above. In the fact of the case, it will not be safe to base the conviction only on the testimony of the PW Ajay, which does not inspire confidence. Now, my 6th judgment is Kanhaiya Lal, with regard to Last Singh. That's in para 13. Now, before para 13, para 7. Para 7. The prosecution case is that the appellant accused Kanhaiya Lal committed the murder of Kala by strangulation and threw the body in the well. Nobody witnessed the occurrence, and the case rests on circumstantial evidence. It has been consistently laid down by this court that where a case rests squarely on a circumstantial evidence, the inference of the guilt can be justified only when all the incriminating facts and circumstances are found to be incompatible with the innocence of the accused or the guilt of any other person. The circumstances from which an inference as to the guilt of the accused is drawn have to be proved beyond reasonable doubt and have to be shown to be closely connected with the principal fact sought to be inferred from those circumstances. Para 11, the circumstances of last seen together does not by itself and necessarily lead to the inference that it was the accused who committed the crime. There must be something more establishing connectivity between the accused and the crime. Mere non-explanation on the part of the appellant, in our considered opinion, by itself cannot lead to the proof of guilt against the appellant. Para 13. The theory of last seen, the appellant having gone with the deceased in the manner noticed herein before, in the singular piece of circumstantial evidence available against him. The conviction of the appellant cannot be maintained merely on suspicion, however strong it may be, or on his conduct. This fact assumes further importance on account of absence of motive, proof of motive, particularly when it is proved that there was a cordial relation between the accused and the deceased for a long time. The fact situation bears great similarity to that in Madho Singh versus State of Rajasthan. Last judgment, my lord. P7. That is also based on last seen together theory, my lord. Manoj alias Munna versus State of Chhattisgarh. I rely on para 26, 27, 28, 29, 30, 31. It explains that 106, my lord, on which the relevant portion I'm only reading, my lord. Para 30. Para 30, my lord. It is settled principle that section 106 of the Indian Evidence Act 1872 clearly provides that when a fact lies especially within the knowledge of a person, the burden of proving the fact rests upon him. Accordingly, when an accused is shown to have been last seen in the company of the deceased, it becomes incumbent upon him to explain how and when they parted away. The explanation furnished must be reasonable, probable, satisfactory in the opinion of the court. If such explanation offered, the burden cast by section 106 of the Evidence Act stands discharged. However, if the accused fails to present a credible explanation regarding fact within his special knowledge, this failure constitutes an additional link in the chain of the circumstantial evidence established against him. At the same time, it must be emphasized that 106 of the Evidence Act does not shift the primary burden of proof, which in a criminal trial always remain in the prosecution. Thus, any adverse inference under 106 of it is to be drawn against the accused person if the prosecution has been able to establish the case beyond reasonable doubt. Para 19. Not para 19. It says para 32, 19. It's a para 33. Above that, para 19 it's stated. Yes. Thus, although section 106 in no way aimed at relieving the prosecution from its burden to establish the guilt of an accused, it applies to the cases where chain of events has been successfully established by the prosecution from which a reasonable inference is made out against the accused. Moreover, in a case based on circumstantial evidence, whenever an incriminating question is posed to the accused and he or she either evades response or offers a response which is not true, then such a response in itself becomes an additional link in the chain of events. Further, further, in the case of Anis versus state government of NCAT, this court held that section 106 of the Evidence Act referred to the above provides that when any fact is especially within the knowledge of any person, that burden of proving that fact is upon him. The word especially means facts that are preeminently or exceptionally within the knowledge of the accused. The ordinary rules that applies to the criminal trials that the onus lies on the prosecution to prove the guilt of the accused is not in any way modified by the rule of facts embodied in section 106. 106 of the Evidence Act is an exception to 101 of the Evidence Act. 101 with its illustration lays down the general rule that in a criminal case, the burden of proof is on the prosecution, and 106 is certainly not intended to relieve it of that duty. On the contrary, it is designed to meet certain exceptional cases in which it would be impossible or at any rate disproportionately difficult for the prosecution to establish the fact which are especially within the knowledge of the accused and which he can prove without difficulty or inconvenience. In view of the above discovery, with the opinion that the nature of circumstantial evidence available against the appellant, though raises a doubt that he may have committed the offense, but the same is not so conclusive that he can be convicted only on the evidence of the last seen together. Be that it may be, it is a settled proposition that whenever any doubt emanates in the mind of the court, the benefit shall accrue to the accused and not to the prosecution.
That is all, Mr. Yes. Yes.
A couple of things.
First, coming up with the judgments that my Lord Junior has referred to. Kanhaiya, my lords, all probability, my lords, talks about late lodging of the FIR. And that too in a case wherein there is no eyewitness to the event. Then, my lords, Sachin, that has been referred to her, that against, my lords, again referred to delay in lodging the FIR. Firoz Khan, Akbar Ali, delay in lodging the FIR when there was an eyewitness. Then, my lords, this Ahmad Sheikh Baba judgment, my lords, para 26, that that is also not applicable in this case, my lords. What is important, my lordship, here is that we all know that Sachin has killed Sabita. There is no doubt about it. Why I say so? There are two evidences that needs to be read together here. One is the evidence, my lords, out of the deposition recorded for PW3. That has to be read with the deposition recorded for PW9. PW9, my lords, happens to be the most crucial and the most important witness, not because he's an eyewitness, but because of the last seen together theory. If I can have, my lords, for a moment on what the PW3 had said, and that also shows the conduct of the accused. Page 15 minutes of the paper book, deposition of PW3. What is also relevant to note here, my lordship, is that PW1, 2, and 3, they are all from the families of the in-laws. They have never ever stated that there was a quarrel between the husband and the wife. It is only the PW9 who has portrayed the correct picture before the court. So they in some way, my lords, because he is ultimately a father, the accused person. So they in some way, my lords, initially they also wanted to protect the accused, in my humble submission. If I can have my lordship for a moment on page 15. What does the PW3 has to say? He says, my son returned home after, I am on 1, 2, 3, 4, 5th line, minutes. My son returned home after playing football. This son happens to be the de facto complainant later on. My son returned home after playing football and my wife went to nearby shop to purchase sugar, and that time my daughter Savita Burman and the husband Sachin Burman were at home along with the 3 children. What is important to note here, my lordship, is that this Sachin, he used to work in Jaipur. It can also be inferred from other depositions that he wasn't doing well with the kind of the laborer job that he was having in Jaipur. Sachin, Sabita, and all the 3 kids, they were residing along with the grandparents' home. Now, in that context, what happens? Subsequently, when I returned home from market, the middle grandson stated to me that his father scolded the elder grandson. Then I asked the elder grandson about the reason of scolding, to which he replied that when my father took my mother to back of the house, I was trying to accompany the mother, and for which my father scolded me. Then Sachin thereby this should be song. It has been incorrectly written as SIGN at 2 places here. I will explain it. Sound song from back of the house. And I got angry and stated to him by saying, son of a pig, why he was scolding the children since I am feeding them. So what is happening here is when the father-in-law is trying to, in a way, Milords, is trying to say to the accused person, then Milords, the reaction that the accused person gives is he's still singing a song. Let's come to the later line, Milords. Thereafter, I called Sachin to come in front of me, but he did not. He was still there near the Kolabagan or in the courtyard. Instead, gave sound song 3 times. He continued singing the song. Suddenly, call came on the mobile of my wife. Now, we need to understand from here what has happened. This person, the accused person, could have straight away said to the mother-in-law that I have killed your daughter. He doesn't do so. When the phone is picked by the mother-in-law, he asked the mother-in-law to hand over the phone to the father-in-law, with whom he had an immediate altercation because he said that, son of a pig, if I am feeding the grandchildren, then why are you scolding them? My wife, and after hearing sometimes, she dropped the phone and after giving a shout, she rushed to the back of the house. The elder grandson also rushed towards the back of the house by saying that his parents are there. Then my daughter was lying there on the earth in the banana garden, the Kalabagan. Now with this, we need to understand the deposition of PW9, because an objection has been raised, my lords, with regard to the fact that when PW9 has given the deposition, he also says that at time he is in courtyard and then at time he is in Kalabagan. And the body where it was found, that is also, there is a little bit of minor discrepancy that has been pointed out. Now, my lords, in the context of PW3, let's read PW9 once again. At the relevant time, I, along with my two younger brother, were studying in the veranda of my grandfather's house. At that time, my mother told my father that he wanted to make a phone call. So on the pretext of making a phone call, and because they occasionally keep changing the SIM, that happens in village areas because there are different companies that offer free SIM for a particular period, and then there are lesser amount of recharges that happen. So calling from a particular SIM gives there is a benefit of free outgoing. My mother and father went behind my grandfather's house, and I also followed them silently. And my younger brother told this fact to my father. Then my father assaulted me on the right eye, and I returned to the veranda and started reading. So till that time, he was following. But when he was hit by the father or scolded by the father, rather, I would say, then he came back and he started staying. And when the grandfather arrives, he immediately informs the incident to the grandfather. When the grandfather scolds the accused, then also the accused was present there and he was singing the song. And thereafter, within a very short interval of time, this incident has actually happened. These through deposition needs to be read together, with the deposition of the doctor, which happens to be at PW 11. He says in the postmortem report that the incident that has happened was neither suicidal nor accidental, but homicidal. Now, if it was homicidal, nobody else was present there. Or at
9 is
least
the younger son.
Yes, so nobody else was present there. There was no opportunity for the accused to come to the washroom and then drink alcohol or poison or whatever it was and make a call to say that I have killed the daughter, which is appearing from the deposition. So Sachin has killed Sabita, not only in fact, Sachin has also killed Sabita in accordance with law. And there is no, he has killed her in accordance with law. Means that in law also it is proved that he has killed her. At least on the last sin together theory. So he has killed her in accordance with law.
Killing in accordance with law?
No, because this is a legal aid matter.
Often we have this urge to kill some people.
He has killed in accordance with law. The circumstantial change is proved, the circumstantial change is very well proved, The child witness has been proved to be a trustworthy witness, The child is the only one who says that there used to be a quarrel between the husband and the wife, which probably the mother never said the in-laws about it. That could be a reason behind that. But the content and the motive is important. In that respect, only one thing I have to say. If today this father is released on bail, then what will happen?
No, we are hearing the appeal.
So if the father is released or acquitted, then what will happen? Tomorrow he will take the father-in-law to the Kalabagan. Next day he will take the elder son to the Kalabagan.
Innocent, he will not do anything.
But next day he can take the elder son to the Kalabagan because he has deposed against him.
So why did he is found to be guilty?
Yes, my lords.
If he is not guilty, then he won't do anything.
So in my
Go to the
humble
Kalabagan by
submission,
himself.
the last scene together is proved. There is a short time gap. Everything that has happened in the Kalabagan is within the special knowledge of the accused, That as per 106 only the accused has to say.
Mr. Bishop, what about this discrepancy between the PW9 saying that saw the body at the courtyard
because
under banana tree?
She was throttled and thereafter dragged. So when the dragging is there, it could happen in the courtyard or it could happen in the Kalabagan.
That's something which you are submitting from the bar. It's not there in the evidence anywhere.
No, dragging is there.
Dragging is there.
Postmortem nowhere.
No, in the deposition dragging is
He
there.
says his neck was broken, something.
Nobody saw him drag her.
No, nothing. IO's evidence is also very important in that case. Because there was no banana.
Ms. Sharka, please. Yes.
So my humble submission, is the manner in which the offense has been done, it is cold-blooded, deliberate, and without any provocation. The deceased who has died, she had no offense to commit. She didn't do anything. She was just a mother.
There are certain judgments cited by your learned friend which says that motive acquires relevance if it is the evidence is circumstantial.
True.
Here it was circumstantial.
True. That is the reason why PW3 I have read to my lordship. Because I was stuck at two different points. One was because initially I was also not able to figure out the motive. But then when I read the deposition of PW3.
Because the father of the wife says, son of a pig, he goes and kills her.
No, he is the one who is feeding the grandchildren.
So
He's, in PW3 statement.
Okay, so what? So you
It is
kill your wife
reflecting.
for that.
So what applies from
He
there?
has been feeding for years.
No, see, he's singing a song when the father is scolding him. He does not replies to it.
That has never been told in
That
161.
is the kind of conduct that he has. What kind of a person would sing a song when somebody is scolding him? That too not once, twice, and thrice.
A person who is innocent may sing a song. If he does not, he has not killed. He may
And
also sing.
thereafter, he will take the wife to the Kalabagan.
After
singing the song
was
or
heard-
before.
Singing was heard from the Kolabagan behind the back of the house. Both two witnesses say that singing was
Even
heard
if
from
even
the-
if singing is before the incident or at the time of the incident or after the incident, what kind of a person would sing a song while doing this kind of
provided
thing?
he had killed somebody. If he had not killed, it's a double-edged sword. Singing may show that he did not do anything. They went to Kalabagan, he was singing, he did not do anything. I mean, that may be another theory. Singing a song is very sinister if after killing he has done it.
Yes.
But provided the killing is proved, singing a song does not prove the killing. It's the other way around. He could have been singing a song because he was innocent also.
The death is homicidal, neither accidental.
Last scene is very strong here.
Last scene is very strong.
Look, there are two or three
He has
corroborating witnesses.
from the core of the fact, he hasn't deviated, neither in the 164 nor in the deposition before that.
Mr. Is the 313 a part of the paper book?
Yes, ma'am.
Can you tell us please where it is? $35, yes.
It starts from page 35. And page 37 is of some relevance, question 11, because that is where PW9 has been, the question has been put by the learned trial judge. Nothing stated by the accused.
Good.
He didn't bother even to explain as to why the son has said something like that in reply to question 11.
Yes, Mr. Reply.
My lord, with regard to the son has said so, the IO had clearly stated in his cross-examination that the father-in-law never stated to him that he has called the son or the son has.
Show us that.
Yes, my lord. Page 33, last two lines. The witness did not state to me under section 1 that when he called Sachin, he gave sound 3 times on the back of the house. And my lord, I have the written notes of argument if your lordship wants to.
When was the incident took place on? Give us the dates. please.
27. The FIR was lodged on the next day,
20.
not immediately.
The incident took place
There was
on
a delay.
27/4/2015. 27/4/2015.
Yes.
FIR on 28/4/2015.
Lordship, I am appearing in this matter. Kide. কিছু বলতেই পারলাম না তো। উনি হচ্ছে অ্যাকচুয়ালি গেলে পরে ওখানে কাউকে না বললে পরে দাঁড়াতে দিচ্ছে না। হ্যাঁ, সৌরভ স্যারই দাঁড়াচ্ছিল।
Lord, if it's item number 11, can't hear your lordships, my lord, at all. There's something. Can't hear your lordships.
Can't hear the
My lord, your lordships at Jalpaiguri, my lord, there's something wrong, my lord, with the microphones. Neither can I hear Mr. Rai, nor, my lord, can I hear your lordship. Until now, my lord, everything was fine, but just because when the matter started, my lord, we just can't hear.
তুমি ওখানে গিয়ে মামলা করো।
আমায় হ্যাঁ, চলো, আমায় নিয়ে চলো।
Yes, in fact, in item number 8, I could hear everything.
Huh.
But 9 onwards, everything has been stopped.
Now I can.
No, this was from Calcutta, wasn't in from
Oh, I
Jalpaiguri.
see. Oh, I see. Okay.
তোমার আইটেম নাম্বার কত?
11.
আচ্ছা, তুমি আচ্ছা,
তুমি
everybody's
plaintiff?
everybody's afraid of the advocate general. Can't help
হ্যাঁ,
it.
এরকম খারাপ চেহারা হলে লোকে তো ভয় পাবেই।
No, no, you are very young.
আচ্ছা, আমাদের মধ্যে কথা নিশ্চয়ই কথাগুলো ওইখানে কোটে যাচ্ছে।
হ্যাঁ, must be. That's true.
Well, at least I can hear.
I cannot hear, my lords.
কি হলো গো?
My lord, I'm appearing for responding item number 12, my lord. My lord, uh, my lord, I'm unable to hear, my lord. কোনটো ফালৰ পৰা মাইকটো বন্ধ হৈ আছে? My lord, I'm unable to from that side, my lord.
My lord,
Thank you.
हम लोग दोनों के वैसे हम लोग दोनों की तरफ से। तो हम उसको उसको मोटा बना के देते हैं, मोटा उसके पास नहीं है। हाँ, बस उसको मोटा कर देगा, ठीक है, और उसमें ना वो साइन नहीं कर रहा है। Execution affidavit sign करवाया है, application sign की client आ रहा है, order 20 days. अन्ना तो आज तक ना order sign अन्ना फोन 20 टोटली तो हम लोग है starting में हम लोग उसी तरह से प्रेरणा नहीं नहीं आप मत
हेलो चेक हेलो
এবার মুক্ত নেই সেকেন্ডে যে বিভাগ মুক্ত হয়েছিল
একটা আমরা সবাই আছি ও
সেকেন্ডে কি পেপার সমেত কমপ্লিট দিয়ে দিয়েছো আমাদের পুরো কনসেপ্ট
বলটা তো বললো এরকম ভাবে আপনাকে দিল চেষ্টা করছেন কি দরকার ছিল
কি হলো হ্যাঁ দেখতে পাচ্ছি আপনি শুনতে পাচ্ছেন কিছু
I am for the Union of India.
What is the matter about? In terms of the last order, my lord, We intended to, my lord, put on record certain documents. Sorry,
This against this is writ appeal, mandamus appeal.
mandamus appeal.
Mr. Ghosh, would it be possible for us to conclude it today? Otherwise, we'll keep it in the next
It
circle.
will take
Lordship,
some
because,
time, my lord, if he wants to have a look at the documents and
No,
Supplemented
Lordship,
if
no,
you-
Lordship, I like to hear the matter because this is a case of audit. Audit by the government. It is only a verification of the accounts. So from prolonged long 1 year, they are not operating us. So it's only we have to see the provision of law.
Mr.
So
Agarwal,
that
you are
will
right.
suffice the thing.
You are right, but
So
it's-
I am not going through the whatever
but
they
there's
have.
no interim order.
it's not possible for us to conclude
So
the hearing and pass
Lordship,
judgment.
at least by going through the act, permit me to conduct the audit because the audit conduct of audit will not prejudice to
You'll have
the
another circuit
appellant, Lordship.
only after a week. Only after a week, you'll have another circuit. So have it before the next circuit. If supplementary affidavit, you want to use anything, you can use.
Yes, Lordship.
If you get the time, you use it. It would be better to use a rejoinder.
No, I will also file the affidavit in the opposition or will bring some document on record.
Very well. A supplementary affidavit filed today by the appellant is kept on record. Full stop, next para. The respondent shall file its rejoinder thereto, comma, if any. We are making it within a week from date so that you can have
No,
it before that.
even before 3 days. Because Lordship, because what is happening?
Here for urgency.
Because this is the government
No, you'll-
procedural thing
Understood.
and it is being hampered.
Within a week from date, within a week won't
3 days or 4 days, Lordship. I will do it.
within 3 days.
Because, yes.
Within 3 days, full stop, the matter be posted under the same heading, posted in the list under the same heading on the first day of the next circuit. So it will be on the first day under the same heading.
Lordship, in the priority to be mentioned. or-
Specially fixed. These are specially, other specially fixed we have,
Because
one only you have
special fix
adjourned.
Sometimes comes in the, because our position is
If we
very,
got this in the first few days, we could have disposed of, but now it's very difficult.
yes, it is not able to reach, that is the bad luck. Deeply obliged.
Thank you. Password.
Passover item, item number 6.
I appear for the state.
Yes, Mr. Rathod. FMA against what? This is a writ appeal. Mandamus. What is the context? Just in a nutshell, Mr. Datta, so that we can pass our judgment here only, yes.
Actually, the direction was given, kindly come to the judgment for us. There are 5.
Yes, para 5.
Accordingly, the application is disposed of with direction to DI. It shall take up immediate steps to ensure the headmaster. So
You are the writ petitioner to headmaster shall DI. Ensure the headmaster.
immediate steps to ensure that the headmaster shall so acts as per order dated 11/9/2025.
Right.
So 11/9/2025 is the order under challenge in this.
Mm-hmm.
And there was direction to give the reasonable opportunity of that. But kindly come to the same order. Same order is in my CAN application. The last page, in page number 104. 104.
Yes.
In the said order, it has direction to take the step as per observation so and so and recast the service book.
You are a teacher in this school.
And the librarian for rectification of the disk. Now this recast after retirement of the employee, whether the recast is possible, that was is not possible, that was not challenged. We challenged in the repetition. And direction was given to follow up this order with giving reasonable opportunity of hearing. Now that means the recast is the
Remains.
there's no option that to recast it.
You are requested to do this. What was your observation of the DPPG?
To recast.
To recast, that is it. So recasting on what ground?
Recasting to that it was mistaken by them for
Nature of mistake?
mistake in the salary basic pay.
What
Scale of basic
I'm
pay.
sorry, my lord, may I, my lord. What my oral instructions are that initially pay fixation, my lord, at the time of retirement was erroneously done. So therefore, my lord, as per the pay fixation, which was erroneously done by the headmaster of the school, the writ petitioner would have got lesser pension. Now, my lord, after this order,
After the
therefore,
recast, he'll get more.
that is what my instructions are, my
We'll
lord.
record that.
Kindly not.
Instruction.
My lord, oral instructions, my lord, today morning I've got. If may I make one humble request, my lord, since this is regarding non-payment of pension, can it be, my lord, your lordship's convenience to keep it tomorrow, my lord? Tomorrow, my lords will be keeping few
One or
cases.
two, three.
One or two, my lord. Since this is non-payment of pension, my
So
lord.
you take proper.
I have, my
instruction.
lord, I will be.
If that be so, Mr. Dattu will record that and will not interfere and request them to do it quickly.
Because another instruction is that the recasting has been done from the end of the headmaster. It is now pending before the district inspector of school.
Just take instruction, Mr.
Yes, my lord.
If that be so, then you will get to know whether he'll get more only.
Yes,
If you
my
get
lord.
more, we are not interfering.
Yes.
Or if you want, we can interfere then also.
Kindly takes
Actually,
it.
we have no application for getting more. Recast is on the form.
No, not your, no question of
No,
your
no,
application. They had made a wrong calculation, they're trying to recast. In principle, there cannot be any interference with that. It's their internal thing. There might have been error. And we could have given you liberty also to challenge the recast scale. Whatever is given to you, you can get an opportunity to challenge that also. We could have given you that also. But if you get more, why should you
No, the
interfere?
difficulty is, my lord, there's an order by which, my lord, provisional pension was directed to be paid. Now this, what I have is illegible completely, my lord. Now that is also I've asked that why a provisional pension, my lord, instead of a, what
Exactly.
happens, my lord, that even if there is a wrong computation in the pension, the pension payment order is issued and a wrong computation, my lord, that pension is paid. Now therefore, thereafter the pensioner, my lord, has the option to challenge it or whatever. Here, my lord, the pension payment order has not at all been issued. A provisional order for a provisional payment of pension and
You take proper instruction, come
Yes,
back to
my
me,
lord,
we'll
I'll do
keep
that.
this matter. This is the one of the 2 or 3 matters.
Yes, my lord, grateful, my lord.
Learn Council for the State seeks a day's accommodation to take appropriate instructions in the matter. So accordingly, let the matter be listed tomorrow.
Grateful, my lord.
Another same heading. 3-4 ম্যাটারই রাখবো, বলে দেবো আপনাকে। এটা থাকবে, এটা একটু মাথায় রাখবে, এটা থাকছেই, আর যা থাকবে বলে দেবো।
Customer item number 7.
7.
I'm for the applicants, my lord. Am I
Yes,
audible,
Mr.
my lord? Yes. My lord, I have served.
Yes, you are audible. Yes, you are audible. What is the matter?
Yes. I have served all the respondents, my lord. My
Appearing.
junior is there.
Mr. Pal is appearing. Mr. Navankur Pal is appearing for the respondent.
He's appearing for the plaintiff.
One has been served.
3, defendant number 4.
Achha, 2 to 4 are appearing. 2 and
I've served all.
you are 2.
These others I have served.
You are 1.
Yes.
You are the plaintiff.
Yes.
Very well. Yes.
Yes.
Yes. What is the matter, Mr. Rai?
Applicants, the applicant number 1 is the husband of the original defendant now. Sorry, wife of the original
Is the-
defendant, Vishnath Ghosh, is the wife of the original defendant, namely Vishnath Ghosh. Applicant number 2 is the son of the original number 2,
Right.
Vishnath Ghosh. And Vishnath
So
Ghosh is
he
the
died,
brother
you
of
are
the
included.
plaintiff. Yes, sir.
Very well.
Vishnath Ghosh is the brother of the plaintiff. The 2 brothers, full blood brothers. Here, my lord, tax is a suit for partition. And I have challenged the preliminary decree before your lordship. And the fact of the case is that, my lord, one Hemlata
The preliminary degree of challenge, Mr. Rai, will pass the usual order then. No final degree will be drawn up because it will continue.
Yes, sir.
That's the usual order. The present, you are doing that. Yes. The present appeal has been preferred against a preliminary decree of partition in a suit filed by the plaintiff stroke respondent number 1. So next para, since arguable questions of fact as well as law are involved, comma, the appeal is required to be heard on merits. Full stop. Accordingly, we find from the affidavit of service which is filed today and kept on record that despite service, the respondent number, you are 1 and you are
3. Respondent.
3.
3.
Respondent numbers 2 and 3, 2 and 4 are not represented. Full stop. Next para. Accordingly, we take up the application for disposal. Full stop. The trial court shall continue with the final degree proceedings, but shall not draw up any final degree without the prior leave of this court during pendency of the appeal. Full stop. Can 1 of 2026 is disposed of accordingly. The appellant, in view of the appearance of the respondent number 1 and 3 through their learned advocates, service of notice of the appeal on the said respondents is dispensed with. Full stop. The appellants shall put in postal costs and due requisites for service of notice of the appeal on the respondent numbers 2 and 4 within a fortnight from date. Full stop. The trial court record shall be brought by special messenger at the cost of the appellants, also to be deposited within a fortnight. Full stop. The trial court shall be at liberty to retain skeletal records for the purpose of continuing with the final degree proceedings. So next para. The appellants shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned counsel for the learned advocate for the appellants. Liberty to the parties to mention the appeal for enlistment as and when the same is ready for hearing. Thank you. Thank you. Yes.
Item number 14.
Yes.
Lordship, I am for the
Litigation.
I'm
To
for
this
the
honorable
NCB,
court.
Lordship. Mr. Majumdar will appear
My
in
lord,
this case. Lordship.
since
Kindly
1
please-
year, when my lord has last dismissed the bail application stating that the paper books are ready and the matter is ready for hearing, since 1 year this stand has been taken, my lord.
What stand? That Mr. Mujumdar is not.
My lord, how
Please, next.
the paper book is custody is, my lord, more than 3 years and 6 months.
So
And there
Shantanu,
is
in
no-
any event, we cannot decide the appeal today.
Not my lord, appeal, my lord, the CRAN application. The CRAN application, my lord. The bail application, my lord.
Yes, what is your defense to the bail? 1 year has elapsed.
Lordship.
How long are you in custody?
My lord, more than 3 years, 6 months, my lord.
What is the maximum sentence?
My lord, the 15, my lord.
Wait till the next circuit.
My lord, since 1 year, my lord, I am waiting, my lord.
Understood.
Kindly see, I have a good case, my lord, because the prosecution has failed to establish the case beyond doubt, my lord.
Shantanu, come back to finish it.
My lord, kindly, my lord,
We
let
have to
them,
hear them because we
my lord,
directed the appeal. to
then,
be
my
heard
lord,
along.
kindly grant me a interim relief, my lord.
What
Any
interim relief?
interim bail
application,
means, my lord, if the matter takes up for hearing, then he will surrender.
After a week, means it will appear before the. We are
My
retaining
lord,
the matter
we
in the
have
list.
tried,
We are just
since 1
adjourning
year,
till-
my lord, I have tried many times, my lord.
An adjournment is sought on behalf of the NCB.
NCB.
Full stop. Next para. Learned counsel for the appellant submits that there is extreme urgency in the matter, and about a year back, bail was refused on the understanding that the appeal would be taken up for hearing. Full stop. Next para. However, till date, the appellants are languishing behind the bars. Full stop. On query of court, it is submitted that the appellants have been sentenced to 15 years of imprisonment and have already spent more than 3 years.
No, 3 years, 6 months, my lord.
More than about 3 years, 3.5 years in custody. Full stop. Next para. However, by an order dated June 10, 2026, it was directed that the appeal itself be listed for hearing along with the bail application. Full stop. Next para. In view of the adjournment sought by the NCB, let the matter stand over till the next circuit. Full stop. However, the same will retain its position under the same heading.
Deeply obliged.
Position in the list under the same heading.
Obliged.
Deeply listed. That will last time.
My lord, can it be made, I don't know, my lord, it can be made that as a last time, because every time, my lord, they are taking the same stand, my lord. Deeply obliged, my lord. Deeply.
Item number 15.
শহীদুল করবো
আমার নাম
বিবেক তরফটা
None appears for the appellant stroke petitioner. Let the matter stand adjourned till the next circuit.
I'm deeply obliged.
Thank you.
Item number 16.
I'm for the petitioner, my lord.
Yes, what is that?
This matter is regarding the suspension of sentence.
There was a direction upon the state to serve the copy to the victim girl that hasn't completed yet. Let's let it be.
Learned Triple AG appearing for the state submits that the service has not yet been effected on the victim girl. Push-up. Accordingly, let the matter stand over till the next circuit with the expectation that the victim girl shall be served expeditiously.
I'm so sorry, my lord. That is that order would be for 17, not for 16. 16.
Yeah, this is regarding POCSO.
16 is also POCSO.
Yes.
Oh.
16 or 17?
No, what I said, my lord, the submission that was with regard to 17.
ওটা কেটে দিও না
Item number 17, the service is not complete yet. Oh,
তাহলে 17 টা পোর্টে দেখো
Item number 17.
17 whatever order we pass that applies to 17 now 16 এ চলে যায়
My lordship, my lordship.
16 টা পোর্টে দেখো
I understood that.
হ্যাঁ অর্ডারটা 17 হবে অর্ডারটা 17 16 17 order passed adjourned till next circuit yes
Lord, I'm for the petitioner, my lord. I'm coming before your lordship court second time.
which section of the POCSO Act
Section 6 of the POCSO Act.
your age victim's age
No,
at the relevant
16
time
copy has not been served upon the state.
No, after service only we can file the.
No, that is true, but we do not have the copy, neither in the office. No. You can give a copy to me and then we can take it.
Learner Triple AG submits that he is not equipped with a copy of the application push-up. Learned counsel for the appellant submits that unless a copy was filed, comma, the appeal could not have been preferred. So be that as it may, comma, learned counsel for the appellant is requested to hand over an additional copy of the application to the office of the learned Triple AG. By tomorrow, full of the matter shall be listed before the next circuit.
May I, small interjection. In item number 70, service is not sufficient. It may be direct to serve the victim. but
Yes,
we
yes,
are-
yes. That is what we have said.
Lordship.
They are already,
That is what we have said.
that is what they say.
Lordship,
yes.
I'm not-
আচ্ছা আগের 17 এ যেটা বললাম না should be effected in the expeditiously by the state actor by the state.
Item number 18.
I am for the petition.
Yes, Mr.
Twenty years and 25 years, my lord. 2 terms imprisonment. I am for,
Run concurrently.
my lord, no, 2 accused persons.
Oh, acha 20 and 20.
Yes,
Very good.
safe.
There's only
Also section 6, my lord.
there's only one appellant.
No, there are 2 accused persons, my lord. Appeal has been preferred by Shundru alias Amit Lohar, who is the present petitioner.
So what
before
is
your
your term?
lord. My term is 20 years, my lord.
20.
Term of 20 years, my lord.
No, we are hearing the bail.
Yes.
Yes. The victim age, what was the age of the victim, Mr. Bishop?
At that time, it was 16.
6. And your age was?
Mine was 24,
Acha, yes.
my lord.
You previously also any bail was rejected?
No. So far, my instruction.
All right.
My lord. The first thing is the statement of the victim. What is the case? Victim went to attend the Shraddh ceremony of a relative where 2 accused petitioners were present. These two appellants were present. Is alleged that
She went to attend Shraddh function in the Masibari. In the Masibari, this Amit Lohar, who is the present accused, he was there. He took her to her own room. Thereafter, she was disrobed and her pictures were taken. So the first offense is the pictures were taken. Thereafter, rape was committed, and then those pictures were transferred to another accused person who serially, so she was treated like a commodity from one person to another person, and the other person has committed serial sexual exploitation. That is what the case is.
Defense lawyer to lage na.
No. Both of them were not present in the massive.
No, both of them. Let me come to that. That is my case, Mr. Mishra. My lord, kindly come to page 9 of the paper book. The statement of the victim girl.
Yes.
মুখস্থ করে রাখলে হবে? My lord, this is her statement. It's to be given the most important part. I study in Banarhat, Balika Porimal Hindi High School in class 10, my lord. The de facto complainant is my mother. She got married to Shankar Munda after separation. At that time, I was 10 years old, not relevant, my lord. In the month of June 2022, I had gone to the house of my elder maternal aunt to attend the Shraddh ceremony with my maternal grandmother. Shundru Lohar was there, as his house is near to the house of my elder maternal aunt. I know him before. He requested me to go with him to his house to bring some articles. I had been to his house. There was no family members in his house. As soon as I entered into the room, he closed the door from inside and disrobed me and made my video. My lord, Shundru told her to go to his house. She went there. He closed the door. He made the video. This is the statement. Somehow I managed to escape from his house and came back to my house. I had not divulged such incident to anyone. Now, up to this, there is no allegation of rape, my lord. This is disrobing, separate offense. Maximum section 8 of the POCSO Act. Subsequently, after 2-3 days, he came to my house and threatened me to make my obscene video viral if I would not make sexual relationship with him. And he did sexual intercourse with me thrice in his house. This is the allegation. His house is within the same garden, tea garden. Thereafter, my lord, it's a very important, but thereafter he sent the video to accused Krishna Mahali, another accused, who is convicted for a sentence for a term of 25 years, my lord. Mahali, whose house is adjacent to my house, Krishna Mahali is also threatened me and did sexual intercourse with me, the pretext of making the obscene video viral. Accused Krishna Mahali did sexual intercourse with me for 10-11 times. I had not disclosed the fact to my family members. Gradually, I fell ill and my mother took me to the Tea Garden Hospital. Dr. Bimal Chetri examined me and told my mother that I was pregnant. But this is also very important. Dr. Bimal Chetri examined. Then, according to her statement before the court, this petitioner, Shundru alias Amit Lohar, took him to his house, disrobed her, made her video.
Need not repeat it. We have.
My lord.
Yes.
Whatever has been done thereafter, and the video was made by him. Thereafter, Krishna Mahali came. My lord, now একটু exhibit file একটু exhibit file ঠিক আছে। This is the 164 statement of the victim. It's an exhibited document, exhibit 2. একটু খুশিকে রাখো খুশি।
Yes.
My lord, I cannot read Hindi. I have to take assistance of my intern.
Let
No, I cannot rely on you. I am on a thin rope. I cannot rely on that.
Let them place.
Madam?
Let them place. They will place it. Your juniors will place it.
Yes, ma'am. My intern. He will read out. She will read out. Yes, dear. Read.
You have deliberately chosen an intern who can speak.
Manoj, I cannot read Hindi, so I have there are
You better
three-
learn soon.
two interns, Hindi knowing intern, one Hindi knowing junior.
Yes, ma'am. What is your?
Can you read?
Read it.
मेरे घर से बड़ी मम्मी का घर 30 मिनट की पैदल रास्ता है। तो बड़ी मम्मी का जब डेथ हुआ तो मैं उनके घर गई थी। मेरे मौसा जी ने कृष्णा महाली और उनके साथ उनका दोस्त सुंदरू महाली था। मौसा जी ने कहा घर में कुछ काम है कर दो, तो उनके साथ उनके घर गई। तो उनका दोस्त सुंदरू महाली मुझे जबरदस्ती पकड़ लिया और पूरा कपड़ा इनर गारमेंट्स भी खोल के मेरे छाती चीपने लगा, यहाँ वहाँ हाथ लगाने लगा। मैं चिल्लाई, किसी ने नहीं सुना, कोई नहीं आया बचाने। कृष्णा ने पूरा वीडियो बनाया और धमकी दिया कि किसी को बताया तो काट के फेंक दूंगा। फिर मुझे ब्लैकमेल करने लगा। दोनों के साथ अगर नहीं बारी नहीं सोई तो वह अश्लील वीडियो सोशल मीडिया में वायरल कर देगा और मम्मी पापा को भी दिखा देगा।
So I think that discrepancy has already come up.
Yes. Now the video was made by Krishna, and in her statement she said the video was made by Chandru and later it was given to Krishna. And according to this statement, both were present. And it is Krishna who took him. The PO place of occurrence has been changed. According to her statement before the court, the first place of occurrence is the house of this petitioner. But according to the 164 statement, the first PO is the house of Krishna. Krishna is the Mosaji who took her to the house of Mosaji for household chores.
So two discrepancies. One is Mosaji took her instead of the appellant taking her.
Yes, ma'am. And the PO is different. Place of occurrence is different. Mosaji took her to his house.
Oh, acha.
And before the court, he stated that Chandru took him to his house. The place of occurrence
उनके घर गए ऐसे.
yes, the place of occurrence is different. And third, who made the videography? There is a complete shift, my lord. He said Chandru made the videography and later gave it to Mosaji. But here it appears from her first statement given to magistrate, from where, which is an exhibited document. She says that the video was that means at that time Mosaji was also present according to her previous statement. That has been skipped. This is the first point of discrepancy. Now I am coming to the age point. Well, kindly come to the judgment at page 31. The specific matter, page 33 matter. List of exhibited documents. The judgment. Another interesting part is that DNA was also conducted.
They conducted.
Yes. Well, this is the list of the exhibited documents. In the exhibit list, the DNA conducted, DNA is not there, but in the judgment, it is appearing that it has been exhibited. In the list, it is not mentioned.
So what is your case? I mean, on the.
Madam, I'm coming. Madam, about the age. Madam, kindly come to the material exhibit. I have never seen document has been made material exhibit. Why I didn't understand this. Original Aadhaar card of the victim card, MAT exhibit 1. This is the only document on the basis of which the prosecution attempted to prove the age of the victim, that is 16 years. 16 is the borderline. Madam, now I am coming to a judgment of the Supreme Court as to how the age of the victim is to be determined. For the section 34, subsection 1 and section joint reading of section 34 of the POCSO Act and section 94 of the JJ Act, there is a guideline. the first document to be considered is the birth certificate. If not possible, a matriculation certificate.
That age determination
Yes,
section of
there are the hierarchy of document is there in the statute itself. First is the birth certificate. If not possible, the matriculation or the school living matriculation or the equivalent certificate, my lord. Thereafter,
cite the judgment.
my lord. Here is the judgment.
Which paragraph?
Yes.
Para 14 you have marked.
Yes, ma'am. Para 14 and 15 are the relevant paragraphs. The procedure has been stated. Which document to be relied? This hierarchy of the document, this is a statutory framework, my lord. The Aadhaar card doesn't find place in this. Now, my lord, whether Aadhaar card can be used as a proof of date of birth, there is a Supreme Court judgment I am relying upon. Earlier, I relied upon.
Only yesterday an Aadhaar card was produced,
Yes,
you
my lord.
gave liberty
Here
to
is the
file.
judgment. May I cite? May I submit, madam? Here is the judgment where Supreme Court stated. Supreme Court refused to consider Aadhaar card as a age proof. After 2018, I found this judgment. In 2018, Supreme Court stated the larger bench judgment. Supreme Court said it is for identification only, not for any other purpose. Here is the judgment. And the notification of the Aadhaar is mentioned here. Now, Aadhaar department is mentioned here, my lord. Relevant paragraphs are para 9, subpara 6, para 9, subpara 9, and paragraph 10. The age of the victim is seriously disputed. In a POCSO case, my lord, when the age, if had it been a case that she is 5 years old girl, my lord, I would not have been able to challenge the age at this stage, my lord. But it is a case where she is 16 years of age, my lord. In the cross-examination, she stated that I passed class 10 that year. But when she joined the school at what is that document is not available. Moreover, my lord, the school, she is a school-going girl, passed a matriculation examination. Those documents were available. Those were not produced for proving her age. That means what is the presumption of law then, my lord? If prosecution has a document, but withholds the document, what is the presumption? If produced, we will go against the prosecution, my lord. That is the presumption of law. Thirdly, my lord, Exhibit 14, that is not in the list, my lord, the DNA test report, my lord. The report, DNA report, my lord. At page 43 of the judgment, kindly come to page 43, my lord. I found, while reading the judgment, I found the discussion about the DNA test. Before that, I didn't know that DNA test was conducted, except from it was exhibited through the IO. Though, in the last paragraph, last 3 lines, my lord, page 40. Though DNA report reveals that the accused Krishna Mahali was the biological father of the fetus, yet the involvement of the accused Amit Lohar cannot be ruled out. Statement of the victim is consistent, that is why he was convicted. But whether that is convincing evidence of the victim, one witness is sufficient to base a conviction, my lord, but that evidence must be unblemished.
So her allegation was that both committed the offense.
Yes, but the DNA test,
one might have been, the paternity of one might have been determined.
my lord,
That does not mitigate your
does not
circumstance.
mitigate, my lord, but does not acquit
Does it
me.
help you as such? Does not acquit
That
you.
can help you. In addition to that, there are discrepancies in the previous statement.
No, those are there. But DNA report,
That
Krishna
alone
Mahal-
cannot help. That alone
moreover,
cannot-
if it is not an exhibit, the court could not look into it also.
My lord.
This observation is rather perverse in a sense. DNA report
Now
is,
coming to another point, my lord.
yes.
The tea garden doctor, who is the first doctor who examined her. Tea garden doctor.
Yes.
That tea garden doctor has not, Bimal Chetri has not been examined by the prosecution.
Not
Neither
fit-
by the police nor by the.
Not fatal.
Very important witness, my lord.
Medical report, she was examined and medical report was furnished, authored.
There are other serious discrepancies, my lord. I have already pointed out age, the
No,
statement.
those are there.
Yes, my lord. And another important aspect, my lord, she said this videography. She said videograph was made. This videography was never brought on record. No 65B, no proof, no exhibit. The videography was never brought on record. Although victim stated that Ria Boshak, who is a friend of the victim, had a copy of it. She saw it in her phone. That Ria Boshak was also not examined, my lord. That part could have been proved by oral evidence. It is not there. And lastly, my lord, the medical examination report, I have to create an exhibit. Medical examination report, Exhibit 1. According to the victim and examination, she even did not disclose the name of the accused persons before the doctor. She even did not disclose our names before my name before the doctor who examined her at that relevant point of time. There was some kind of family arrangement, sometimes some kind of thing was going on, madam. The age is seriously disputed. The statements are tarnished.
No, the history is not there in this.
History is that is written at the bottom, madam.
That is opinion.
That is the opinion according to the victim and examination, madam.
Yes.
She did not mention the names. And the doctor who detected the pregnancy at the fasting point of time is an important witness. He has not been examined.
Yes, Mr. These are. Yes, Mr.
I'll say first thing first, with regard to going seriatim, my lords, with regard to the age of the victim, if I can have my lordship for a moment on page 7 and 8, para 10 of the judgment, because it has been dealt with there.
Para 10 of which page?
Page 7, internal page 7 of the judgment. In paper book, it is 37.
37.
Yes.
Section 200 of the POCSO Act defines child as the person below the age of 18 years. Therefore, the first and foremost aspect which needs to be scrutiny for primary application of Section 6 is the age of the victim at the commission of the offence. It is the case of the prosecution that incident was reported on the PS on 10/5/2023, and at the time of occurrence of the incident, the victim girl was aged about 16 years. In order to substantiate the same, original Aadhaar card of the victim girl was produced and marked as MAT exhibit such and such. In course of argument, learned defense counsel admitted that age of the victim girl has not been established beyond reasonable doubt to show that she was a minor at the time of occurrence of the alleged incident. He has also submitted whenever there is a dispute with respect to age of a person arising in the context for him or her being a victim under the POCSO Act, the court have to take recourse to steps indicated in Section 94 of the Juvenile Act. 3 documents in order of which the Juvenile Act justice requires consideration, those documents has been referred to minutes. Then thereafter it says, on perusal of that document, I find that the date of birth of the victim girl is 1/1/2007, which means the victim girl was 16 years of time of initiation of this case. From the medical,
Mr. He totally, please, Mr. He totally relies on the other.
no,
part.
the medical legal examination report is also there. Just after that, from the medical legal examination report, I find that the age of the victim girl was mentioned as 15 years.
No, it was not an ossification test or any
No,
sort of-
ossification test was.
So how medical legal examination report? Mr. Bishas, please take your seat. Please take your seat. We request you to take your seat.
I am sincerely apologizing.
Mr. Medical legal examination, the term is heavy, but it was not an examination of her age.
It is not an ossification test for sure.
Nothing. It is nothing. It
Yes,
has
yes,
no
yes.
authentication regarding
Yes,
the age.
yes.
The victim, whatever the victim disclosed or whatever else was there. Doctor's opinion is not relevant regarding her age.
Yes, Mr. But what has played in the mind of the court, Mr.
The
is
court,
below that.
we find it is the duty of prosecution to establish beyond reasonable doubt original Aadhaar card produced. So in absence of contrary evidence, therefore he relies on the Aadhaar card only, which is not a valid proof of age. In POCSO, age is the primary consideration.
No, it also says that in the absence of any contrary evidence.
That is
produced
what
by
we
the-
read.
Yes, 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 yes.
So in the absence of any contrary, provided the primary evidence is clinching, I mean, at least establishes the age even prima facie. The unique identification authorities themselves say that it's recorded in the Supreme Court judgment that it's not a proof of age. And it's probably written somewhere also in the Aadhaar cards now.
In the Aadhaar card,
In the Aadhaar card
Aadhaar
somewhere
Act, it says that it is only for the receiving subsidy and everything. There
Yes,
is
yes.
nothing-
Now
Yes.
it's they have started writing it also probably somewhere.
Yes, yes, yes.
So therefore, age goes. And what about this major discrepancy, 164? POCSO, we are very heavy on the accused, against the accused.
No, in that case, what has happened?
There's a
my lord,
serious
is-
discrepancy.
Yes, page 11.
Mausa
para
takes
60.
her to his house. One,
That is only one said, but thereafter. her
but it's a
statement-
different house altogether. The place of occurrence. In her evidence, she says this: the appellant took her to his house, to the appellant's house. These are two different places altogether. First, secondly, Krishna was also there at the first instance. Then in evidence, it gets changed, material change. Krishna was not there. Mausa was not there. Only appellant was there. He did the thing. He took photographs. And then he threatened her, thrice committed the offense. Then Krishna came into the picture. It was given to him. He also started doing it. It's a major discrepancy.
But then not on the every other count, the court has held that the witness, the evidence given by the witness was of sterling quality. It has been repeated at least thrice at 3 different occasions. There is no denial of the fact that the video was there.
Video was not produced.
No,
No
video was
question of
never
denial.
seen.
You have to discharge your onus.
The friend of the who happens to be Milord's
Riya was never produced. Riya Bashak.
she was not produced.
She was not produced. Provided there is a foundational fact is established, only then there is a question of rebuttal, Mr. Bishra. In POCSO cases, as you say, we are very serious, but this is a serious discrepancy. 164, I say somebody else's house and Mausa was there. I mean, Mausa being there is another factor we have to consider. And here it is said that he told her to go and she went with him to his house.
No, this Mausa happens to be Krishna Mahali, who is the father.
Mausa is Krishna Mahali.
Yes, as per DNA profiling. So that is not there.
Does not come up in anyway. Does it come up?
It does. It does.
It is considered or in the evidence somewhere?
Yes, yes, yes. it
Mausa
does.
is the Krishna Mahali.
The role of Krishna Mahali.
He is Krishna Mahali.
Mosha is the DNA.
Mausa is Krishna Mahali. And this Mausa is the father of his DNA
Fetus.
profiling has been done. He's the father of the fetus. This Amit Lohar, he took the pictures first and then he did whatever he has to do and then he
There is a
transferred the
discrepancy in the my lord.
transferred the
Who
pictures
recorded it
to
and-
Krishna Mahali.
In the evidence, she said that it was recorded by Sandru, and in her previous statement, she stated it was recorded by Mausa.
This Krishna Mahali and Mausa,
And
they are
given
both
to
friends.
Mausa later. Some serious discrepancies there.
কৃষ্ণ মালি শুধু তাই না এভিডেন্সে আরো ডিফারেন্স আছে এভিডেন্সের হচ্ছে পেলেন নিয়ে গেছিল পেলেন
No, but I just overheard it. When she says that she went to the Masi Badi for the Shraddh, that means that Mausa Badi and Masi Badi are the same.
No, my lord. He resides somewhere else. 2 sketch map of the PO are different, my lord. 2 POs have been differently marked in different sketch maps.
Krishna Mahali, has it come up in evidence anywhere that Krishna Mahali was the Mausa she was speaking
Yes,
of?
yes. Yes, it is there.
Show us that.
Krishna Mali?
Was the Mausa?
Yes.
Where do we find it? You want to?
Yes, it is.
In her statement, I think.
Is there any case made out by the prosecution that there was any other Mausa or something?
Krishna Mahali
No, there
has
is no
been
other.
sentenced to 25 years imprisonment.
We understand, but
Page 9.
Yes,
What?
my lords. Page 9, para 13.
Para 13. Where?
page 9.
Krishna Mahali also threatened. Just a moment, my lords. Elder maternal uncle to send such and such. She knew she.
Yes.
Krishna Mahali lives somewhere near
Yes,
the
yes.
house
Last
of
line.
the
Last
victim.
line.
my lord.
Last line. 1 week accused Krishna Mahali, who was the maternal uncle. And in the deposition also, she has said he is the Mossa.
Yes, he is the Mossa, my lord.
He started blackmailing.
In the 164 statement of Mossad, he has been written, my lord. Krishna Mahali. And DNA is indicating towards Krishna Mahali, my lord. There are other discrepancies. Humbly pray for a bail.
So the,
And videography was not produced. That is one of.
No one.
it was never seized. But the video was there, through in and throughout.
You cannot say that.
Yes, that's true. Because it was not
How
seized.
long are you in custody, Mr.
My lord, from 2021.
The punishment that has been awarded to him is not
20 years is a term.
20 years and 50,000.
20
And
years
for
is a
Krishna
term.
Mahali, it is 25 years and 1
No,
lakh
we are not
rupees.
for Krishna
No,
Mahali.
no, we understand.
50,000 has been stayed, no?
No.
He has paid 50,000. You have paid 50,000.
My lord?
50,000 you have paid.
That I'm
No,
not
no.
sure.
Very poor people, my lord. Poor Bagania people, they are really poor. Mr. Mishra,
We don't find any reason for incriminating this person. I mean, no motivation is there. Nothing has come out from defense evidence that there was any reason for, particularly for
The
implicating
defense
you.
did not lead any evidence.
Why should you
he
be
is not
implicated?
bound, my lord. Let me make it clear. My lord, when the presumption triggers only when the fundamental facts are proved.
True, foundational facts
But
are
if the foundational facts, the age is a foundational fact, one leg is not there.
age is foundational fact for
He is one of the foundational facts,
bringing
my
under
lord.
POCSO.
Yes, my lord. Thereafter, my explanation.
But then the
comes.
trial is vitiated because it's.
Yes, my lord. The entire trial will go. In this case, also trial was vitiated because of age. Age was not. There is a fair chance of acquittal.
So
my
you
lord.
are behind the bar for about 4.5 years. Or
Yes, my lord. With strict conditions.
what sort of strict condition do you contemplate?
My lord, I will not leave the territory, or I.
You reside in the same police station area of the victim girl.
Yes, my lord.
Yes.
Then. Will not
But
enter.
I will stay outside the territory. I will work somewhere outside, and I will share my location with the investigating officer. And put in appearance as and when directed by this court.
Discrepancy কিন্তু serious. শুধু এর ক্ষেত্রে কৃষ্ণার তো কিছু করে কৃষ্ণার বিল মুভ করবে না অনুরোধ।
And now there is no question of tampering with the evidence, my lord, because evidence has been concluded.
Yes, we are granting bail unwillingly.
My lord.
Unwillingly, we are granting bail.
My lord.
My lord.
God's grace.
Should we record unwillingly? So that the order is
Willingly, my lord.
perverse and they can get a good
My
order in
lord may record
challenge.
willy-nilly.
The present appeal has been preferred against by one of the convicted persons in an offence under the POCSO Act, under several sections of the POCSO Act, including section 6 and any other section?
Section 6. Conviction under section 6.
Under sections, various sections, under section 6 of the POCSO Act.
Read with 506 of IPC.
Read with section 506 of the Indian Penal Code. Full stop, next para. Learned counsel for the appellant, comma, in support of the application for bail in connection with appeal, comma, contends that there are serious discrepancies and lack of foundational facts found from the materials on record. Full stop. First, comma, the victim girl, comma, in her statement under section 164 of the Code of Criminal Procedure, comma, categorically stated that her uncle, her maternal uncle, comma, within bracket Mausa, M-A-U-S-A, bracket closed, comma, one Krishna Mahali, comma, who is the co-convict, comma, had taken her to his house where she was ravished and a videography was done. No, sorry. Yes, videography was done. Full stop. Next para. No, in a section 164, she said that you took her. No, Krishna Mahal. Yes. And a videography was done, which was subsequently used to blackmail and exploit the victim girl. Push up, however, comma, in her evidence as PW1, comma, the victim girl stated that the appellant took her to the appellant's home where similar offense took place against her, and the videograph was taken by the appellant and not Krishna Mahali. Pushed up, in the narrative of the PW1's deposition, comma, Krishna Mahali enters later into the picture, comma, when allegedly the videos taken by the appellant were circulated to him, and using the same comma, Krishna Mahali also took a similar course of action against the victim girl. Push up, next para. It is submitted that such patent contradiction regarding not only the place of occurrence, but also place of first occurrence, but also the persons who are present vitiates the prosecution version as a whole. Push up, next para. Secondly, comma, it is argued that the foundational premise of a conviction under the POCSO Act is the age of the victim. Push up, learned counsel places reliance on such and such reported at 2024-17 SCC 684, where the Honorable Supreme Court observed inter alia that it is evident from a conjoint reading of Section 34 within bracket 1 of the POCSO Act and Section 94 of the Juvenile Justice Act that wherever the dispute with respect to the age of a person arises in the context of her or him being a victim under the POCSO Act, comma, the courts have to take recourse to the steps indicated in Section 94 of the JJ Act. Full stop, next para. As per the same, comma, the three documents in order of which the Juvenile Justice Act requires consideration of the age is first, comma, the date of birth certificate from the school, comma, or the matriculation or equivalent certificate from the examination board, B capital, concerned, comma, if available, semicolon, in the absence thereof, comma, the birth certificate given by a corporation or a municipal authority or a panchayat, above semicolon, and only in the absence of the above two, comma, age shall be determined by an ossification, OSSI, test or any other latest medical age determination test conducted on the orders of the committee or the board. Full stop, next para. In the present case, comma, however, comma, only the Aadhaar card of the victim girl was produced, which is not even a valid proof under either the POCSO Act or the JJ Act or under the Aadhaar Act. So next para, in support of the last above mentioned contention, comma, learned counsel relies on Saroj and others versus such and such reported at 2024 SCC Online SC 3038, where it was observed that Unique Identification Authority of India, comma, by its circular number 08 of 2023, comma, has itself stated, comma, in reference to an office memorandum issued by the Ministry of Electronics and Information Technology dated December 20, 2018, comma, that an Aadhaar card, comma, which can be used to establish identity, comma, is not per se proof of date of birth. Full stop. Next para. Learned counsel submits that in the absence of a foundational age proof, comma, the rigors of the POCSO Act and the trial thereunder are palpably vitiated and entitles the appellant to an acquittal. Which of next para, from the DNA report, comma, although the same was not exhibited, comma, the learned trial judge also came to the conclusion that the other co-convict, Krishna Mahali, within bracket, the maternal uncle of the victim girl, bracket close, was the father of the child, was the
Biological father of the fetus.
was the biological father of the fetus. Thank you. Fetus. Full stop, next para. Thus, comma, the involvement of the appellant is also not established from the said DNA report. Full stop. It is next submitted that the first doctor of the tea estate, comma, who examined that the doctor of the tea estate who examined the victim girl first after the offense was not at all examined or cited as a witness. Push up next para. Importantly, comma, it is further argued that the allegation of the prosecution was that videography was done of the victim girl in compromising position, which was repeatedly used to blackmail her and forcing her to subject herself to the offenses. Full stop. However, comma, no videography was brought on record at all, comma, let alone satisfying the parameters of section 65 capital B of the Indian Evidence Act. Full stop. It is submitted by learned counsel for the appellant that as per the prosecution version, comma, one Ria Boshak, comma, a friend of the victim girl, saw the said videos, but she was not even cited as a witness. Full stop. Next para. Also, comma, the names of the accused persons were not mentioned by the victim girl before the examining doctor, comma, which is reflected from the medical examination report which was exhibited in the case. Full stop. Next para. Learned Triple AG submits that the learned trial judge proceeded on the premise that no contrary evidence to dislodge the presumption raised by the Aadhaar card as far as the age of the victim girl is concerned, comma, was produced on behalf of the defense. Full stop. As such, comma, it is contended that in the absence of any other rebuttal evidence, comma, the learned trial judge was justified in relying on the Aadhaar card to come to the conclusion as to the victim's age. Full stop. Next para. It is also submitted on behalf of the state that the so-called contradictions pointed out by the appellant are minor in nature. Full stop. Learned Triple AG submits that although the videography was not exhibited as such, comma, those were actually those actually exist. Full stop. Next para. Upon hearing learned counsel for the parties, comma, we find certain serious lacunae prima facie vitiating the indictment of the appellant under the POCSO Act. Full stop. It is settled law that proof of a valid proof of age of the victim is a sine qua non for conviction under the POCSO Act. Full stop. As laid down in P. Yuva Prakash Supra, comma, the Honorable Supreme Court categorically observed that even in respect of a victim under the POCSO Act, comma, the parameters of section 94 of the JJ Act are applicable. Full stop. Aadhaar card, comma, unfortunately, comma, does not find place in any of the documents to prove the age of the victim in the said provision. Full stop. Despite the victim girl admittedly studying in a school, comma, no effort was taken by the prosecution to bring on record the birth certificate from the school, comma, or any equivalent certificate. Full stop. Next para. Thus, comma, since no valid presumption of the age was raised in the first place, comma, which is a foundational premise of conviction under the POCSO Act, comma, non-rebuttal of the same pales into insignificance. Full stop. Next para. Secondly, comma, the contradiction between the between the statement of the victim girl under section 164 CRPC and her deposition is also crucial. Full stop. Not only does the place of occurrence in between the two versions change, but also the persons who are present at the first instance of the offense. Full stop. Next para. The two versions, comma, one that the appellant took the video when he was there alone with the victim girl, and circulated the same later on to the other co-convict does not go well with the second version that the co-convict was also present and took the videography at the first instance of the offense. Push up next para, moreover, comma, in the present case, comma, the prosecution relies heavily on the alleged videography of the victim girl being used as a pivot of blackmail and repeating the offense several times. Push up, however, comma, such crucial evidence, comma, surprisingly, comma, did not come on record at all. Full stop. Next para. Insofar as the DNA and DNA argument is concerned, comma, we are not much impressed that the same by itself mitigates the alleged offense. Full stop. However, comma, in view of the above observations, comma, we find serious discrepancy in the prosecution case. Full stop. This court is aware that a bail application post conviction is not a hearing of the appeal, and as such desists from going further into the merits of the case. Full stop. Next para, we are also aware of the fact that mere lacunae in the prosecution case does not necessarily constitute a mitigating circumstances for grant of bail or a conviction. Full stop. However, comma, as serious the standards of bail in a POCSO case may be, comma, in the absence of proof of the foundational fact to attract the provisions of the said statute, comma, we do not have any option but to grant the benefit of doubt for the purpose of bail to the appellant. Push up. Next para. However, comma, we make it clear that the above observations, comma, for the present, above observations are restricted to the appellant and not to the other co-convict who is not before us. Push up. Next para. In view of the above, comma, CRAN 1 of 2025. 2025.
Can one?
What is the CRAN?
Cran
26. CRAN 1 of 2026 is allowed, comma, thereby granting bail to the appellant on condition that the appellant furnishes a bond of rupees. You have to furnish a bond, Mr. Monetary bond, of rupees 10,000 with 2 sureties of like amount each, one of whom must be local.
Local may not be given. Poor people, they cannot afford local. Ultimately, they will.
He resides in a different place.
Besides, no, in the same area.
So why can't he afford a local witness?
No, my lord. The entire amount has to be paid. 10,000 rupees, this amount has to be paid.
10,000.
The victim, the accused, they are all from the same PS.
Then?
My lord, no. It is not about a local man standing. It is about the payment of money. 10,000 has to be paid. Otherwise, in registered treasury, 20% is to be paid. This is the practice. 20% of the amount is to be given to the surety.
One of whom must be looked at. Full stop. Next para. To the satisfaction of POCSO Court.
Special Judge, POCSO Court, Jalpaiguri.
Special Judge, POCSO Court, Jalpaiguri. Full stop. The appellant shall not, comma, during the pendency of the appeal, comma, enter the territorial jurisdiction of the police station where the victim girl resides. Push up. Next para. That apart, comma, the appellant shall not make any attempt to intimidate, comma, contact and or reach out in any manner the victim girl or any of the witnesses during the pendency of the appeal, and shall make himself available as and when so required by the appellate court. Full stop. This is sufficient.
Obliged.
Deeply obliged.
Before my lord raises, may I make one?
Yes.
Prior to that short recession, my lords informed that after the recess, the fixed matter will be taken, then the 2 passovers, and then the list will continue. My mistake, lordship, when I came, Mr. Bishop already started item number 15, which is a part out matter. It's a part out matter.
My lord, just
15 is a part out matter.
Lordship, I have given the bunch of documents to the court as well as to the state also, as because state needed time to.
15 টা কি করেছি?
Next circuit.
We are cancelling the parted also. We can't hear it. We have. ওই
Sorry, only technical ground, 2 minutes only.
No, no. 15 এ একটা
Well, tomorrow-
লাইন অ্যাড করে দিতে হবে যে
tomorrow-
নিয়েছে। No, no. Tomorrow we are not. Uh,
Go out of the list, liberty to mention. Then it is
No, no.
automatically out.
No, no. The parted marking in the matter stands cancelled. ওই এটা শুধু অ্যাড হয়ে যাবে যা অর্ডার আছে তাতে। Whatever order is there, it remains.
Tomorrow.
No, no.
Deep your law.
Mr. Chairman, for the respondent claimant.
Why was it, why did you mention? You mentioned it?
Mentioned.
Why?
For necessary order, Lordship, they filed appeal in the year 2025. Thereafter, we are in dark. We are the claimants.
So what are you wanting now?
In a specific direction so that appeal can be heard.
Acha.
And he appears according to his choice. Comes from Kujbihar. I'm called several times.
You are for the appellant?
I am for the respondent claimants.
Yes. Learned counsel for the respondent, claimant stroke respondent submits that necessary directions be passed for the appeal to be heard expeditiously. Full stop. The appellant is accordingly directed to put in special messenger costs for bringing the trial court records within a fortnight from date. Full stop. In view of the appearance of the respondent through his learned advocate, service of notice of the appeal on the respondent is dispensed with, and the appeal be treated to be ready as regards hearing. The appellant shall prepare and file the requisite number of paper books within 6 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. Liberty to the parties to mention the appeal and can 2 of 2025. The appeal, liberty to the parties to mention the appeal for enlistment along with the stay application as and when the appeal is ready for hearing.
Deeply placed.
Item number 2.
It আমার contempt. This is the second occasion when none appears for the petitioner at the time of call. Full stop. Accordingly, CPN 1 of 2020 is dismissed for default. Next.
Item number 3.
Same order.
Item number 4.
I am for the petitioner, Your Lordship.
Yes. You have served?
Yes, my lord.
Good service affected? Received?
No, my lord. I had to file a supplementary affidavit. One application was not annexed in my.
Oh, acha. Order 2017 was none. Please remind me what is the matter?
Your Lordship, I am challenging the order dated 8/1/2026, where after 2 years they have come filing this application. Order 18, Rule 17.
After 2 years from start of the trial?
No, the trial was started from 2015.
After 2 years from what?
The trial was actually going on ex parte, my lord. So PW1 was examined ex parte. After that, after 2 years, they have come and they are saying that they want to re-examine PW1 again.
The present revisional application has been preferred against an order whereby the application filed by the defendant stroke opposite parties under Order 18 Rule 17 of the Code of Civil Procedure, to recall PW1 for the purpose of cross-examination, was allowed. Which learned counsel for the petitioner argues that the said application was made after about 2 years of adduction of evidence by PW1, which secondly, it is contended that the suit had previously been fixed on the ex parte board and was proceeding ex parte in the absence of the defendants. Thus, there was no scope for permitting cross-examination of PW1 on recall at the behest of the defendants. Thirdly, it is argued that the scope of recall arises for the purpose of elucidation of any statement made by the witness in his examination in chief. Therefore, it is doubtful as to whether for the purpose of cross-examination, such recall should be permitted. Full stop, there is substance in the contention of the petitioner's arguments, and accordingly, the revisional application is required to be heard on the above issues. Full stop, accordingly, the petitioner is directed to serve a copy of the revisional application as well as the supplementary affidavit filed in court today pursuant to direction of court, comma, on the opposite parties, indicating that the revisional application shall next be listed in the next circuit for hearing. Full stop. You want a stay of the further proceedings of the suit has to be stayed.
Yes, my lord.
The
Today was actually the date fixed for evidence in the trial court.
all further proceedings in title suit number 277 of 2015 pending before the learned civil judge bracket junior division at Shiliguri shall remain stayed till August 31, 2026 or until further order, whichever is earlier. The appellant the petitioner shall file an affidavit of service on the returnable date. I am granting a limited stay because we will have an opportunity to get it heard. Yes.
Item number 5.
Yes.
My lord, in this case, I am appearing so.
I am for the petitioner. That is your side. My lord,
You are appearing suo motu means?
Yesterday, I was going to file caveat, then I noticed one in this case pending.
So you have been instructed by the opposite party to appear for them.
my lord, this is that matter when where I took leave for filing without certified copy. That is that matter. Without certified copy.
But
this
then
is
you give, since she is appearing, you give a copy to her.
I will, my lord. But since it is in motion stage and there
What
was
is the
not
matter
in
about?
caveat,
What is the matter about?
my lord, the ex parte, I am suffering the ex parte decree. The ex parte decree was passed against me on 1st July 2025, and the ex parte decree of eviction. And the summons which was served upon me, it appears to be malafide, my lord, because it was not personally served upon me, it was served by hanging. And that too in presence of a person who resides almost 10 to 15 kilometers away from my house. Now I question myself how he identified my house. No indication in the service report. So in this way, the ex
So
parte
what are you challenging here? What order is challenging?
my challenge is that I prayed for execution of the I prayed for stay of the execution proceedings. Since as soon as I got to know about the ex parte decree, I preferred an application under Order 9 Rule 13, seeking setting aside of that decree. On that very ground, the no summons was served upon me. And due to pendency of this application, I made an application to the execution proceedings that the execution proceedings may be stayed till this application for setting aside of the ex parte decree is heard. And my petition was rejected, and the impugned order is in page number 103, my lord. Answer I. And the relevant portion is in 104.
Yes, what do you have to say?
Petitioner be directed to supply the copy.
Yes, but the execution case has to be stayed for a limited period. Otherwise, if it is executed, the revision will become infructuous. We'll direct them to serve copy immediately today.
Date for hearing may be fixed.
We'll direct it to appear in the next circuit itself. Very well. The present challenge has been preferred against an order whereby the judgment debtor stroke petitioner's application for stay of the execution case in connection with an ex parte decree passed against the petitioners was, there is only one petitioner.
Two petitioners, one petitioner, my lord, and the other defendant, that is the son of the petitioner, has been added
Against
as
the
a
petitioner
performer respondent.
was rejected, was dismissed. Whose next parallel, and counsel for the petitioner submits that the stay application was filed in connection with an application for restoration of the suit under Order 9 Rule 13 of the Code of Civil Procedure, comma, which is still pending. Full stop. It is submitted that a prima facie case for hearing the said restoration application on merits have been made out to the effect that summons was not duly served on the petitioner. Full stop. First, comma, The process server served the summons apparently by hanging on the door of the premises in question. Such summons was apparently, such service was apparently identified by a person who resides at least 10-15 kilometers away from the suit premises, and as such, it is in doubt as to whether proper identification could be made by such a person. Next para. From the impugned order, it transpires that the learned trial judge learned executing court proceeded on the premise that the application was not maintainable under Order 21-29 of the Code of Civil Procedure, although it is well settled that it is the substance of the application which is to be seen and not the caption. However, the learned trial judge, despite observing that the provision of section 151 could be invoked, refused to do the same, since in the opinion of the learned trial judge, learned executing court, it would override or bypass an express provision in the Code of Civil Procedure enumerating that execution must proceed unless legally stayed. However, such approach is prima facie contrary to law, since the filing of an application under Order 9, Rule 13 of the Code of Civil Procedure entitles the petitioner therein to seek stay of the connected execution case. Next para. At least till the disposal of the application under Order 9, Rule 13 of the Code of Civil Procedure, the further proceedings of the execution case ought to have been stayed. Next para. Thus, the revisional application is required to be heard on the above questions. Since, what is your name, please? Who will appear on record? You will be signing the Vakalatnama?
My junior is signed Neha Sahani.
Since Ms. Kakoli Bose, learned advocate, submits before the court that she has instruction to appear through her learned junior on behalf of the decree holder / opposite party, the petitioner is directed to serve a copy of the revisional application on Ms. Bose, through her junior, which will be deemed to be good service on the opposite party. Next para. However, as no caveat was lodged, there is no impediment in granting interim protection to the petitioner. Accordingly, there shall be stay of all for.
Say something.
Yes.
Order number 6, dated 9 May 2024. Someone was duly served.
No. We are not going into the maze.
Certificate copy is there only.
Accordingly, there shall be stay of all further proceedings in title execution case number 16 of 2025 pending before the learned civil judge, senior division at Siliguri till August 31, 2026 or until further order, whichever is earlier. Next para. The matter shall be listed next before the next circuit. Next para. It is made clear that that since no affidavits are invited, it is deemed that none of the allegations made in the revisional application are admitted by the opposite party. The court also records the objection taken by learned counsel having instruction to appear for the opposite party regarding the allegation that summons were not properly served on the petition. I've recorded.
Extremely good.
Thank you.
Item number 6.
Mr. Roman, you are appearing?
Yes, ma'am.
What is the matter?
There's an order of enforcement of the order of injunction. I have challenged that order through police help. But the impugned order is at the last page.
You have not challenged the injunction order?
No, my lord, it was past ex parte. I came to know of the entire suit when the police visited with this.
So why should it be stayed? If there's an injunction order, it should be implemented.
It takes up the relevant portions. It takes up first the plaint itself. It is the plaint case that the petitioner herein has filed this instant suit claiming a decree of perpetual injunction and
Yes.
other relief. So it is an injunction simpliciter in the first place. That's a page 18, my lord.
Maybe there is no bar.
And there's no bar, but the initial observations at the time of granting of the ad interim injunction by the learned trial court, that is to be taken into account. Malad takes up page number 25, Malad. These are the initial observations. The plaintiff is not in possession. I have my house and I have the grocery store there. Now, what is happening because of the injunction order that has been passed and the police help? I'm not challenging the injunction order. Injunction order is in the form of a
No,
status
this
quo.
police help order was passed without hearing you.
Without
No,
hearing me.
You are
And-
given a notice must be.
No, not at all. I came to know of the entire thing when the police came to my premises.
Learned counsel for the petitioner argues that by the impugned order, the learned trial judge erroneously directed police help for implementation of an ex parte ad interim injunction order, which was passed behind the back of the present petitioner. For next para, it is submitted that the defendant stroke opposite party in the suit, defendant in the suit, defendants in the suit, that is the present petitioners, categorically allege that the plaintiff stroke opposite party is not even in possession of the property, and as such, the injunction could not have, ought not to have been passed. However, since the same was passed ex parte, the petitioners did not have any opportunity to raise such question before the learned trial judge. It is submitted that it would be premature to direct police help to be granted for implementation of an ex parte ad interim injunction without giving prior opportunity of hearing to the defendants. Next para, apart from the above issues, it transpires from the impugned order itself that the police help application was filed by the plaintiff, after obtaining the ex parte ad interim injunction order, by a put-up petition. There is no whisper in the impugned order that any prior notice was given to the opposite party in respect of the police help application. Also, the police help application was allowed ex parte at the first instance without giving a reasonable opportunity to the opposite party to oppose the same. Furthermore, it appears from the impugned order that the foundational satisfaction of the court as to the opposite party having actually resisted the injunction order despite knowing of the same has not been, does not find place in the impugned order. Accordingly, the revisional application is required to be heard on the above questions. The petitioner shall serve a copy of CO number 85 of 2026 on the opposite party, indicating that the matter shall be listed for hearing in the next circuit when an affidavit of service shall be filed by the petitioners. There shall be stay of operation of the impugned order bearing order number 22 dated June 25, 2024, passed by the learned civil judge, junior division at Jalpaiguri in title suit number 157 of 2019 till August 31, 2026, or until further order, whichever is.
There are two orders. One is the order number 22, another is the subsequent order. It was corrected. It was the correction order. 22 and 23.
Impugned
both have been-
orders.
Yes.
Being bearing order number 22 dated যেটা বললাম, dated June 25, 2024, and order number 23 dated June 27, 2024, both passed by the Jabolo, learned civil judge. Thank you.
Grateful. Great.
Next.
Item number 7.
Copy served on the other side.
Yes.
You are happy. You file your affidavit of service also. Yes.
Well, only some documents we are to rely that they have got the copies, but that has to be filed by the affidavit in opposition. But as because they say they have got the copies, I can supply.
Then. Yes. What is the matter?
My lord,
Mr. Mitra, you are happy. Yes. What is the matter, Mr. Mitra?
my lord, it's an application under Order 7 Rule 11 was dismissed. Against that, my
Yes.
lord, the instant application has been filed. Kindly come to the plaint, page 21. At 22.
Yes, 21.
Kindly come to page
22.
22. My lord, 21 is not required. 22, kindly come.
Very, yes.
Lordship will find, my lord,
22.
suit valued at, my lord, declaration and injunction valued at 200 rupees. Then paragraph 2.
Yes.
Defendants had transferred suit premises to so-and-so, Irish, a partnership firm being represented by its partners, Punit Dwivedi, resident of so-and-so, etc., etc. Well, names are not required. Then kindly come to paragraph 4.
Yes.
That the Irish partnership firm has opened a restaurant, bar, cafe, and pub at Planet Mall, second mile, Shevok Road, Siliguri, in the name and style
Sir,
of
your
suite.
voice is not coming. Your voice is not coming. It has been interrupted.
Yes, Mr. Mitra, your voice is not coming. It will be...
That's same problem possibly.
Yes, yes, it is
Oh,
coming
no,
now.
no, it's coming.
Coming now,
It's
coming now.
intermittently getting cut off. Anyway, continue. We'll try to hear you. Yes.
So then, my lord, I shall try to cut short, my lord. Then
Yes.
kindly come to, my lord, paragraph 5.
5 years.
Due to paucity of fund and other complications arising in running of the business in partner, the partners of Irish, the partnership firm and its partners agreed to sell out the entire suit premises and business under the name and style of Swedish at such and such, and after negotiation with the partners of Irish at its registered office, an oral agreement was made between the plaintiff and Irish. I have nothing, no role to play. Then kindly come to paragraph 7. That on 6 November 2020, when the plaintiff had asked the partners of Irish firm regarding the delay for the transfer of the right and for obtaining the necessary permission for the plaintiff to run the business, the Irish firm bluntly refused to transfer the said business. Am I audible, well?
Yes, yes.
Yes.
So, bluntly refused to transfer the said business or any right therein in favor of the plaintiff. Then, my lord, kindly turn the page. That on 17th November 2020, Akash Prasad, Punit Dwivedi, that is the partners of the Irish, they have suddenly entered into the said bar and pub under the name and style of Swedish. Kindly take note, my lord, 17th November 2020.
Yes.
Then, my lord, kindly come to paragraph 9. That thereafter the above named plaintiff has filed a CR case number such and such of 2021. So 20, then 2021. Then, my lord, kindly turn the page. Paragraph 10. Thereafter, one of the partners of Irish firm, namely Punit Dwivedi, had lodged a FIR against the plaintiff, that is Aman Gupta, being such and such, case number 2021, 512 of 2021. Then subsequently, the next paragraph, subsequently, the plaintiff has filed a money suit, now title suit number such and such, against Irish firm and its partners before the such and such court. So it ends at 2021. Then kindly come to paragraph 12. That on 8th May 2025 at about 5 a.m., the above named defendants, namely so-and-so, they had tried to enter into the property. That is the defendants. Now, my lord, there is nothing to show that, my lord, the plaintiff was, my lord, in possession of the property, my lord, from 2020 or 2021 onwards. Nothing, no averment. Then, my lord, kindly, next, this is the only allegation, paragraph 12. And then, my lord, paragraph 17, cause of action arose on 8th of May. That is the day. Now, kindly come to the impugned order.
Yes.
My lord, the impugned order, my lord, dated 23rd of February 2026. Kindly come to the second page of that order.
Yes.
And the second paragraph. The plaintiff, on the other hand, has stated that he is in possession of the suit property.
Yes, yes.
And that he cannot be dispossessed without due process of law. I have nothing to say about the second part, but he is in possession of the property. There is no amendment. Then, The only question that is required to be answered here is that whether, while assuming the facts stated in the plaint to be correct, if the plea of demurrer as raised by the defendant can stand its ground. The plaint reflects that there is a cause of action. The documents pertaining to the year 2020 relied upon by the plaintiff shows that he was exercising possession 2020. Kindly take note. The the exercising possession, the recent holding tax receipt and the maintenance charge receipt shows that the defendant number 1 is paying the municipal taxes. The question, however, at this stage remains that who has the trade license to run the business in respect of the shop room in the mall. None of the parties have filed any trade license or any other document like electricity bill, etc. The recent documents are in the name of the defendant number 1 and the previous one were in the name of the plaintiff. Therefore, there is a cause of action, my lord, with greatest of respect. It is for the plaintiff to prove its case by pleading as well as by, my lord, cogent documentary evidence. My lord, there is nothing. That, my lord, the plaintiff was in possession from 2020 or 2020 onwards. My lord, there is nothing, no averment, no document.
But Mr. Mitra, should it be decided at the 7-11 stage? That is what, one question which is troubling me.
My lord, yes, absolutely. The plaint has to, my lord, forgetting about, my lord, does the plaint say, my lord, that I was continuing, my lord, after 2021, I was continuing in possession? It does not say that, my lord. I think, my lord, I personally think that, my lord, this averment is required, that I am in continuous possession and then you have tried to insert my possession. Otherwise, my lord, the whole difficulty is tomorrow, my lord.
True, but if he shut out the plaintiff at this stage by 7-11, under 7-11, then I mean, this is a curable defect they can put in by way of an amendment also. And,
my lord, they have not tried.
They can otherwise.
They have not tried to, my lord. They could have tried to, my lord. When I made the application, I was expecting this, but when I make the application, my lord.
Yes, exactly.
The amendment applications are made during pendency.
So your ground is non-disclosure of cause of action.
Yes, purely.
All right. Let us hear the other side, Mr. Mitra. Yes. What do you say?
May I seek only one indulgence, my lord?
Yes, Mr. Mitra.
My lord, I have a matter fixed at 2:30, my lord. May I take leave by June?
Yes,
the matter will be in competent hands, my lord, I am certain. Kindly allow me, my lord. Otherwise, it's a fixed matter. Otherwise, I would not have sought this.
No difficulty. Very well. Yes, please.
My lord, before I coming to the applications, we just have to come before the application they have filed in this case, in this revisional application. My lord will find the main contention is that there is no cause of action in the
non-disclosure of cause of action.
No, non-disclosure, obviously, non-disclosure of cause of action.
Yes.
And they have in paragraph number.
In the revisional application?
Yes, which filed before the
revisional application.
Because my lord, this is a supervisory jurisdiction.
Yes, only they are invoking the jurisdiction.
When the supervision, the error of law and error of fact should not be agitated. They have categorically mentioned there is an error of fact and error of law in their
Forget that ground.
That should not
satisfy me from the plaint that you have disclosed that your possession has been stated anywhere that you are in possession.
Now that has to be gathered from all the documents which I have relied before the lower court. That has to be.
In the plaint you have to rely.
My lord, plaint as well as the documents I have filed along with the plaint.
Yes.
That I have
settled.
My lord.
Right. The court has discussed the documents.
My lord.
2020 you have produced a document of possession.
My lord.
A subsequent document is in their name, the recent.
No, my lord. It is their submission, but they have not filed any such document in that respect. It is there.
You are handing over the documents only which you have filed along
with the list of documents. My lord, it is the list of documents I have filed. Maintenance in Gupta. Well, this is the trade license as well as the maintenance of the mall that has been maintained by the committee thereon. That document, a list of document has been filed along with the shoot. My lord will find it.
Aman Gupta, you are Aman Gupta.
I'm Aman Gupta.
So where is your name?
My lord, it is there, my lord. Aman Gupta is. I'm
Swedish.
Swedish is the name. Aman Gupta is there.
Everything in the name. Oh, yes.
And there is Aman Gupta is there, my lord. Last portion, my lord.
Permanent certificate. Oh, achha, in this
Last
also.
portion. The Swedish Aman Gupta. Total due amount is that. My lord, handwritten, my lord.
Yes, yes, Aman Gupta. And
Now
also
this is the planet.
Permanent certificate of enlistment is also.
There is the permanent certificate of enlistment, which categorically submits that I am in the possession of the premises. Now, my lord, regarding.
No, then it's a dispute mixed question. It has to be decided in trial.
Mixed question of law and fact, my lord. Now, this is one of the aspect. Other aspect is the Irish, which is the company they have given. They categorically had mentioned that I have transferred the premises to the plaintiff. My lord, I am handing over the certified copy of the application which I have filed.
Where?
Which they have filed in senior division 61, the case which has division relied. 61 money shoot, that is 61. They have stated now in the plaint. Title shoot number 61.
You have stated in the plaint.
In the plaint. There they say we have filed a money shoot against the Irish.
You have stated
yes, that is our shoot. Against that they have filed an application before the civil senior division.
That is not a part of the
But my lord, in that application they have admitted that they have handed over the position to me.
We cannot look into any other document. We can look into these documents and the plaint.
So
from these documents itself, you say that there is at least some evidence to show that you are in.
We are in the position as well in the. Yes. Now, if the CR case is concerned, which is there also, my lord, the CR case I have annexed that copy. From the policeman has made the report. From that report, it is also transfers that I am in the position. My lord, kindly peruse the report. I am handing over the police report, my lord. My lord, this is the report, certified copy.
CR case, you relied on the CR case?
Yes, my lord, I have relied on the CR case. This is a certified copy of that CR case.
Where have you stated about this? Yes.
My lord, I have stated it.
PS case you have stated in para 10.
Yes, my CR case.
Where is the CR case? Which paragraph of your plaint?
My lord, I am coming.
Yes, yes. Several PS cases.
After PS case, there is paragraph number 9, my lord.
9.
Of the plaint.
Yes, yes. I'm looking at the plaint only.
CR case has been filed in 40 of the.
Yes, yes, right.
My lord, now the report.
No, report you have stated about the report here.
That report has been mentioned here, my lord.
Yes, yes. Submitted a report.
Report.
That report shows that you are in position.
That report shows I am in the position.
Yes, what do you say? Arguable at the time of trial, not plain rejection case.
All the documents are up to 2020.
That's arguable that they have to establish that in evidence and on trial it has to be done. 7-11 if you shut out. The present challenge has been preferred by the defendants in a suit for declaration and consequential reliefs, including permanent injunction. Push up next para. Learned senior counsel appearing for the defendant stroke petitioners argues that although the plaintiff has sought for permanent injunction to protect his purported possession, now inter alia to protect his purported possession, comma, there is not a whisper in the four corners of the plaint as to the plaintiff being currently in possession of the suit property. Thus, comma, the plaint does not disclose any cause of action. As such, comma, it is argued that the learned trial judge committed a jurisdictional error in overlooking such fact and rejecting the petitioners plural apostrophe application for rejection of the plaint for non-disclosure of cause of action comma, filed under Order 7, Rule 11 of the Code of Civil Procedure. So next para, learned counsel appearing for the plaintiff opposite party hands over to the court, but I'll have to keep this on record because I'm referring to this.
My lord, if Xerox copy is given, my lord.
Yes, that
I
will.
will.
So
do
during the
it.
course of the day, do it.
My lord.
Relies on documents which were, comma, in turn, comma, relied on in the plaint and or referred to therein. Push up from the said from several such documents, comma, such as a report filed in a criminal case by the police and a permanent certificate of enlistment as well as other documents, comma, it is prima facie made out that the plaintiff stroke opposite party is at present in possession of the suit property. Thus, comma, it is argued that the question raised by the defendant stroke petitioners is at best a mixed question of fact and law, comma, which is to be decided on trial. Next para, upon hearing learned counsel for the parties and perusing the documents handed over, comma, which were referred to and or relied on in the plaint and stroke or filed along with the plaint, comma, it is clear that the dispute as to whether the plaintiff is currently in possession of the property, suit property, is a mixed question of fact and law, comma, which is to be thrashed out by adduction of evidence by both parties at the time of trial. Next para, however, comma, the court cannot accept the argument of the petitioners that mere non-mention of a specific statement in the plaint to the effect that the plaintiff is till date in possession of the property vitiates the premise of the cause of action and tantamounts to non-disclosure of cause of action. Next para, for the purpose of adjudicating an application under Order 7, Rule 11 of the Code of Civil Procedure, comma, the court has to have a meaningful reading of the entire plaint. Next para, from a conjoint reading of all the paragraphs of the plaint, comma, it transpires that a sufficient prima facie cause of action has been made out for filing the suit, comma, inasmuch as the plaintiff has categorically alleged that the defendants came to the plaintiff's shop premises and started to assault the plaintiff's security guard physically and started to enter into the plaintiff's shop premises forcibly by breaking the lock and key with an intention to commit dacoity. Next para, the very tenor of such statement clearly discloses that the plaintiff is in possession of the property, comma, if the plaint averments are to be taken to be true. Thus, comma, it cannot be said at this juncture that no cause of action has been made out by the plaintiff, which, comma, in any event, comma, is not a germane consideration for deciding an application for rejection of plaint. The court merely has to see whether any cause of action has been disclosed, which it is found from the plaint to have been disclosed. Hence, comma, non-mention in so many words that the plaintiff is still continuing in possession does not per se vitiate the suit as a whole and stroke or amount to non-disclosure of cause of action. In such view of the matter, comma, this court does not find any jurisdictional error committed by the learned trial judge in rejecting the application under Order 7, Rule 11 of the Code of Civil Procedure. However, comma, it is made clear that the rejection of the application under Order 7, Rule 11 of the Code shall not preclude the parties from raising the issues raised in such application on a proper trial on evidence at the time of hearing of the suit. Accordingly, CO 58 of 2026 is dismissed on contest on the in the light of the above observations, comma, thereby affirming the impugned order bearing order number 14 dated February 23, 2026, passed by the learned civil judge, junior division at Jalpaiguri in title suit number 351 of 2025 within bracket R. What is R?
My lord,
What is R within bracket R?
I have to.
That is the usual numbering here. Or
I
should the R be there in the?
That is a registration number.
Oh, then R there. That should number 351 of 2025.
322.
One
My
indulgence.
my lord, I have the Xerox copy of that certified copy, if my lord permits.
Hand that over. And the other remains. The other one is.
That document is Xerox documents. That is it.
One indulgence, my lord. We are disputing their possession, my lord.
That is the
No,
matter.
no, that is the entire premise of my order. That you have. That is the question on which it has been heard, and I have kept it open to be decided on trial. Thank you.
Grateful.
Urgent certificate copies. No orders to cause urgent certificate copies. Oh, sorry. Certified copy টা ফেরত দিয়ে দিছি।
Item number 8.
Registration application
Registration application.
within time.
Within time, service has not been done.
Service has not been done. They were present on that date.
They are present.
Fair enough. The petitioner shall serve a copy of Can 2 of 2026 to the opposite party through the opposite party's learned advocate who appeared at the stage when the matter was dismissed for default and file a receipt in that regard on the returnable date. Full stop. The application shall next be listed before the next circuit. Thank you.
Item number 10 with 11.
9 with 10.
9 and
10 with 11.
9 and 10.
Yes. Yes.
Lordship, it's a second appeal before your lordship.
You're looking like Michelangelo's David. That. Yes.
On the last date, we have mentioned that cross-examination, cross-objection has not been.
Lordship, the copy has not been served upon me.
Admitted.
Achha, very well.
So-
I'm formally recording an order. COT 2 of 2025 arises out of the self-same judgment which has been assailed in the present appeal. Appeal has already been admitted.
Appeal has been admitted. Substantially.
Next para, let the said cross-objection be heard along with the appeal. First up, a copy of COT 2 of 2025 shall be served by the respondents on the learned advocate for the appellant during the course of the day. During the course of the day. First up, next para, paperbook directions and all were
One
given.
indulgence, Lordship. Paperbook
paperbook
direction, there was a
Direction
paperbook
was
direction,
there,
but TCR has not been before your Lordship. So
No,
Lordship-
you put in special messenger cost.
No, Lordship, no notice was served upon me from the department also that the TCR has arrived.
So unless it is served, you cannot
So
do
kindly,
anything.
if
You
the
cannot do-
reminder may be, Lordship, given,
Oh.
because it's since 2020.
What reminder? You move the register then.
Lordship.
The memorandum of the cross objection shall be incorporated in the paper books to be prepared in connection with the appeal. Other directions are already there. What reminder? Who does not remind the?
Lordship, since they are not sending it on. Wait for Lordship. May I please?
Yes.
Item number 11.
11, my lord, I'm for the petition, your lordship.
Yes. Move the matter.
I am for the respondent.
This is a matter where I said that you have to start.
Yes, lordship.
Good. Start. You are for the opposite party.
I am for the opposite.
So you start with a handicap. She is junior to you.
Lordship, the impugned order, they have.
Lordship, yes.
You are for the opposite party.
I am for the
Yes.
opposite.
Let us start.
Oh, acha, no, no, no.
You start with a handicap because she is junior than you. That's why you start with a handicap in this school.
No, Lordship.
Yes, that does not mean you lose. Yes, ma'am.
Lordship,
What is it?
Lordship, this application has arisen, lordship, after the rejection of an order 26 rules 9 by the Civil Judge Senior Division Jalpaiguri. Lordship,
You are the plaintiff.
I'm the plaintiff.
Suit
indeed.
is for?
Suit is for declaration of title and recovery possession and means profit, consequential and relief, lordship.
So what was the ground? Fishing out evidence?
Fishing
Rejection?
out evidences, lordship.
Acha, what is the necessity of this investigation? Let us see. Is there any boundary dispute or anything?
Lordship, yes, we claim that they are encroaching our land and they have started cultivating over the land.
Where have you stated that?
Yes,
Encroaching?
lordship. Lordship, in the
Plaint.
plaint, lordship,
Which paragraph?
plaint. Lordship. Paragraph number 15, Lordship. Kindly page number 21.
You are the junior of whom?
I am working with Devoshidhar. I'm assistant in this matter to Bhaskar Roy Mahashaya.
Oh,
Assisting
Mr.
him,
Rao.
yes.
Aspect, yes. Where is the allegation of encroachment? Let us see.
Yes, Lordship. Paragraph 15, Lordship.
15, but read out the
Yes,
portion.
Lordship. The defendant number 1 company runs the that and
Forget the first
the
sentence,
adjacent-
yes.
Yes,
Unlawfully
yes.
tantalizing, whatever. Some people,
Unlawfully tantalizing
so
some
they are
people at
instigating
the-
your people.
Yes, Lordship.
So where is the encroachment allegation?
Lordship and
Oh, forcibly started
possibly
trespassing.
started cultivating.
Yes,
Illegal tea plantation. The defendant number 1 forcibly started.
forcibly occurred.
Yes,
Very good, yes.
trespassing the occupying the disputed
And
lands.
let us just see the prayer once.
Yes, Lordship.
You have also asked for recovery portion regarding a
Yes,
portion.
yes, Lordship. And also we prayed for the men's profit that they are conducting.
No, that's
from the-
different.
yes,
For min
Lordship.
profits, the investigation is not necessary. Acha,
Yes,
where?
Lordship, the prayer number C, a decree for recovery of possession of the land.
Yes, I've
described in
seen.
Schedule
I've
A.
seen. I've seen. Illegally, unlawfully grown.
Unlawfully,
Acha,
yes, Lordship.
their written statement has been annexed
Yes,
here.
yes, Lordship.
Show us the paragraph where they rebut 15.
Start the Lordship in this in their written statement. They categorically also mentioned that they are not encroaching.
Where is that?
That is in paragraph number 29, Lordship.
29.
Kindly,
Yes. 29.
page 47.
Yes, found.
Yes. In the first paragraph, last line, Lordship.
They say suit properties are different properties, not
different
connected
properties.
with.
No,
Acha, very
Lordship,
well.
this also, and in page
Third-
46.
Acha.
46, second paragraph, last line. The defendant number 1 never encroached upon or occupied any land of the plaintiffs of the suit properties, Lordship. That their contention that they didn't encroach on the
No,
over our land, Lordship.
page 46.
46 paragraph, second paragraph, last line, Lordship.
Acha. Never encroach, yes. Very well. And please show me your this order 26 rule 9 schedule.
Yes, Lordship, it's in it's last page, page number 66, Lordship. The order. Rejection and application was in page number, Lordship,
Need not.
59, and it's a P3.
No, where is the I mean schedule?
Rejection?
Schedule of
Schedule,
inspection.
Lordship, in page 62.
61 is starts
60,
from
it starts from 61, then consecutive 62, 63.
Let us see the impugned order once.
Yes, Lordship. It's it's page number 66, Lordship.
certificate copy.
Sorry, my lord, I was on page.
But he will argue. You lose the matter, but he will argue. Because I am against you, prima facie. Subject to hearing, you will not junior. Yes. Let us hear them.
Lordship.
Lordship,
Yes. What is your full name?
Tanya Bhumik.
And what is your full name?
Satyam Sarkar.
Satyam Sarkar.
Yes, yes.
Very well. Yes. Yes, Mr. Sarkar.
Lordship, they have filed a suit for declaration of title, recovery of possession against us, Lordship. So their contention is that we have been encroached the land and they have been dispossessed. Our written statement, we are denying the dispute. We are stating that no.
So therefore, local investigation is the best evidence.
No, Lordship, the matter is kindly see the schedule of the RIN and kindly see the prayer also. Lordship, kindly come at page number, Lordship, 24, 25. 24, it starts from the 24. Lordship, a
Yes.
decree declaring, Lordship, may I?
24, yes, please.
Yes, a decree declaring the right title interest in respect of the respective lands. That's already denoted the respective lands of the plaintiff described in schedule A, B, and C. Lordship,
B and C, pairs B and C. Reliefs B and C. Recovery of possession. And C also recovery of possession by removing illegally, unlawfully grown on the land of the plaintiffs.
Lordship,
And in
describe-
paragraph 15, they categorically allege that you have encroached. You
Lordship,
deny that in your
Yes,
register.
and they have specifically given their boundary also butted and bounded, they have specifically also.
The dispute
given.
is not that, not regarding the identity. There are two types of disputes requiring investigation. One is identity of the property is disputed, which is not in dispute here.
No.
Nobody is disputing
No,
anybody's.
I am not disputing the boundary.
No.
also. No.
Not boundary, but they are saying that you have encroached on a portion of their property. You have taken a stand in a written statement, Mr. Sarkar, that you are in occupation of a different property. Your lands are different from theirs.
Yes, except one plot.
For that local
yes,
inspection, and
except-
also you have denied the encroachment. So the local investigation, the commissioner has to go, survey pass commissioner has to go, look at the scheduled property and maybe see your title deeds, whatever, and to ascertain whether you have encroached on their land or you are on your land.
Then Lordship, kindly see the prayer therein. They have
See the prayer, I've seen
Lordship,
the prayer.
they have making contradictory. Their plain, they have given the specific boundary that there is a land. They know there is a land. They have the knowledge that there is
And
a
you are
specific.
encroaching on that land.
That is my. That will I will make my defense before the Lordship Trial Court with my written
They have
trial.
to
It
establish
is
their
subject
case.
matter of the trial.
How do they establish that you are in occupation, you have encroached on their land?
They-
Because in the teeth of your averment in your written statement that you are not encroaching first. Secondly, you are in occupation of a different land, not their land. It is to be seen whether you are in occupation of a different land. They have to go and see whether you are in occupation
kindly see their
of their land or your land.
Lordship, kindly see the prayer also. Lordship, kindly
See the prayer by
Lordship,
appointing who will hold local.
to ascertain the suit land. We have to ascertain the suit land, to ascertain to the effect whether the land belong to the defendant lies within the area of the land. They are also described. They are
Unless
also
the land is
entering into-
ascertained, unless the land is ascertained, how can it be discovered whether that is encroached or not? First, the commission has to first ascertain what is their land, what is your land. Your case is you are in occupation of a different land, not their land. So their land has to be ascertained, and then it is to be seen whether you are in occupation of that. Let us see the entire prayer.
Lordship.
Yes, Lordship.
So investigation and identify Schedule A and draw a sketch map in order to ascertain suit land. Otherwise connected to the land of the, because you have taken a stand that you are on a different land.
Lordship, I have taken a.
So it is to be seen whether their land and your land overlap.
That can, Lordship, their prayer itself also showing that whether I am local features and also the position of the suit land also has to be. The position, whether the position can be determined by way of local commissioner, my lord.
See, normally it is not, but where there is a dispute regarding encroachment, it has to be done by local investigation, which will be one of the pieces of evidence. That will not be conclusive. It will be a piece of evidence. In certain cases, generally possession is not determined by this man. But where there is a dispute as to whether you are in occupation, your occupation is, you are in occupation of some land, they are in occupation of some land. Whether your stand in the written statement, Mr. Sarkar, is that you are in occupation of a different land. It has to be seen upon comparing with the deeds or whatever, that whether the occupation, your occupation is on their land or your land. For that purpose, it is necessary. Even in some cases, suppose in eviction suits, reasonable requirement, alternative accommodation is to be shown. There also possession is to be seen, who is in possession. In some cases, possession is required to be seen.
But that will, from the very of the case, that will also affect the trial also.
That is the crux of the case, dispute. It's
Because-
squarely the best evidence.
Because as well as I have not only entirely I have denied, I have also accept there is one plot also which is within the 1623 schedules at page number 47. I have already also stated that all the it is submitted that the defendant Khotian plot number, except there is also one plot on which I have certain portion. It will also come under the same periphery, Lordship. If this
So
will
why
be
are you
planned.
shying away from this? Let that come out. That is
Lordship,
precisely what is
my
required to come
only,
out.
my only contention is, Lordship, we have neither dispute their boundary nor dispute their land.
No.
And
That is not the
rather,
question.
Lordship,
That's
they,
beside the point.
Lordship, and regarding their ascertain, how can the suit land be ascertained by way of commissioner, Lordship? They
He'll
have-
go see by comparing with the deeds.
I have let it be through
That
court,
is how
Lordship.
the commission, survey pass commissioner holds the commission. Mr. Bhattacharya, you want to add anything to Mr. Shah?
Lordship, because Lordship, can see, they have.
They have done what? They have trespassed also into your land.
Yes, the prayer B also, Lordship, kindly see.
Prayer B of the?
Prayer B of their order 6 rule 9. to ascertain to the effect whether there is any land belonging to the defendants lying within the suit land.
Precisely. That is your case. You are in occupation of your land, not their land.
But certain portion also.
That
There
will
is
be
a certain
ascertained
portion.
whether you are correct or they are correct.
And Lordship, once this application is allowed,
Allowed, then the facts will come out.
the facts, no. It will directly hamper, it will directly also hamper. Yes. Lordship, it will be directly enter into the fishing of the evidence.
Concept of fishing out of evidence is that when it is required, it may be proved by other evidence, then no investigation is required. But here, that is the best evidence.
Lordship, they can prove by way of their
They can,
deeds
but
also.
they-
Their deeds,
But they are
their
already
maps, by way of
denied.
maps also they can prove before the court.
Let them prove in this manner. And then they'll give maps. and-
Lordship, then if it would be, then on all the recovery of possession, then this application will be entertained in all kind
If
of.
there is an allegation of encroachment in all the recovery suits, it should be entertained. If there is an
Then-
allegation of encroachment and that is denied, all suits, you're right.
Yes, but Lordship,
In
kindly
all suits where encroachment is alleged, this should be done. And if this is not done, then adverse inference should be drawn against them, against the plaintiff. Not in this case them, I mean the plaintiffs. And that is done in cases. There several judgments are passed in that fashion, that you have alleged encroachment, you have not even asked for a local investigation. And you are regularly entertaining such appeals. You are alleging encroachment, you did not even ask for local investigation. How is it ascertained, to be ascertained? Your oath versus their oath won't do. No, sir, you have tried your best. Ms. Tania Bhomik, learned counsel appearing for the petitioner submits that the learned trial judge refused to exercise jurisdiction vested in the trial court by law by dismissing an application under Order 26, Rule 9 of the Code of Civil Procedure filed by the plaintiff stroke petitioner. Full stop, next para. Plaintiff stroke petitioners. Full stop, next para. It is argued that the plaintiff categorically alleges that some portions of the suit property, belonging to the plaintiff's stroke petitioners, has been encroached upon by the defendant number 1 stroke opposite party company and its men and agents. Full stop, next para. Such contention has been controverted by the defendants in their written statement. Full stop, not stopping there, the defendants have also stated that they are mostly in occupation of their own property and not the plaintiff's property, stroke the suit land. Full stop, in the teeth of such allegations and counter allegations, it is submitted that the best evidence would be survey past commissioner's report by way of an investigation, local investigation under Order 26, Rule 9 of the Code of Civil Procedure. Full stop. However, such aspect of the matter was overlooked by the learned trial judge, who proceeded on the premise that the suit was merely for declaration of title, recovery of possession after evicting the defendants, and as such, it is not required to get a report about the physical possession in respect of the suit land. Full stop, the learned trial judge also observed, according to the petitioners erroneously, that the petition was with an intention to fish out evidence. The next para, Mr. Shottam Sarkar, led by his senior Mr. Bhattacharya, argues that the application was one for fishing out of evidence. Full stop. It is submitted that possession cannot be ascertained by visual inspection. Full stop. That apart, in the written statement, the defendants have admitted that they are in occupation of a portion of the suit property, but substantially they are in occupation of their own land. Full stop. Next para, learned counsel submits that the dispute raised by the defendants is that the property on which the defendants are in occupation belongs to the defendants, but there is no dispute as to the boundaries or the identity of the suit properties. Full stop. Thus, the parties have to prove their respective cases on the basis of their own evidence and documents and not by way of a local investigation. So next para, learned counsel reiterates that the application is a ploy of the defendants of the plaintiffs to fish out evidence by undertaking a roving inquiry, whereas the facts in dispute might very well have been proved otherwise. So next para, on a consideration of the averments made respectively in the plaint and the written statement, comma, it transpires that the plaintiffs stroke petitioners have categorically alleged that the defendant number one company has forcibly trespassed and encroached upon a portion of the suit property, which, comma, according to the plaintiffs, comma, belong to them. So next para, in the written statement, comma, on the other hand, comma, the defendants have squarely denied that they have trespassed upon the plaintiff's property and have also stated that the suit properties are different properties and not connected in any way with the land stroke properties of the defendant number one. Next para, thus, comma, in view of the nature of disputes involved in the suit, comma, a local investigation would be the best mode of adduction of evidence in order to establish the issues in dispute, the facts regarding the issues in dispute. Full stop. Contrary to the contention of the defendants, comma, this is not a case simpliciter where possession of the parties is sought to be ascertained by visual inspection. Full stop. The allegations and counter allegations of the parties also pertain to the question as to whether any portion of the plaintiff's property has been trespassed and encroached upon by the defendants, and stroke or whether the suit properties are different and not connected in any way with the land stroke properties of the defendant number one. Full stop. Next para, hence, comma, commissioner's report would be the best piece of evidence which could be produced in the suit. Full stop. Next para, in the prayer portion of the Order 26 Rule 9 application, comma, the plaintiffs have sought a local investigation identifying the Schedule A, B, and C properties of the plaint and drawing a sketch map of the suit property, তারপর double inverted মধ্যে, in order to ascertain the suit lands as well as ascertain whether the suit property otherwise connected with the lands of the defendants, double inverted close. Full stop. Next para, thus, comma, the local investigation is not merely for the purpose of ascertaining the suit lands, but first to ascertain such foundational fact and thereafter to proceed on an inquiry as to whether there has been any overlap between the defendants and the plaintiff's property. Full stop. Hence, comma, the learned trial judge proceeded on an entirely erroneous premise in observing that the suit was merely for declaration of title, comma, recovery of possession and eviction, comma, without taking into account the aforesaid facets of encroachment as alleged by the plaintiffs and denied by the defendants. Full stop. Next para, the concept of fishing out of evidence only applies where, comma, despite the issue in dispute being amenable to proof by other better modes, comma, a party seeks a roving inquiry. Full stop. Next para, however, comma, in the present case, comma, it is not a roving inquiry, but an incisive ascertainment which has been sought by the plaintiffs, comma, which has germane bearing on the disputes involved in the suit. Full stop. Thus, comma, the concept of fishing out of evidence is not attracted to the present case at all. Accordingly, the impugned order cannot be sustained in law. Hence, CO number 22 of 2026 is allowed on contest, thereby setting aside the impugned order bearing order number 70 dated December 8, 2025, passed by the learned civil judge, senior division, Jalpaiguri Shodor Court in title suit number 31 of 2012, and directing the learned trial judge to appoint a survey past commissioner to conduct local investigation in terms of the prayer made in the plaintiff's stroke petitioner's application under Order 26, Rule 9 of the Code of Civil Procedure. Full-stop, such appointment shall be made within a week from the date of communication of this order to the learned trial judge. Whosoever it is expected that the commission work shall be completed at the earliest, preferably within 1 month from the date of appointment of the commissioner, in order to expedite the hearing of the suit. No orders to cost urgent certificate copies. Very well argued, both of you. Yes. Next.
Item number 12.
Worship, in this matter, I am for the appellant.
Very ill argued by you. Yes. You are for the appellant is no argument. What is the matter?
Worship, I have a CAN application. 7,492 delays are there.
Serve a copy and come.
Worship, may I come tomorrow? I will serve.
No, not. Don't come back tomorrow. I don't want to see you tomorrow.
Only one, only one.
You serve
item.
copy and come back
Worship,
after.
I come after serving.
Section 5, all benches are legal. Don't worry. The appellant shall serve copies of CAN 1 of 2026. The appellants shall serve copies of CAN 1 of 2026 on the respondents, indicating that the application shall be listed in the next circuit when the appellant shall file an affidavit of service to that effect. Next.
Item number 13.
Yes.
I'm representing on behalf of the appellant.
Yes. Service has been effected on the insurance.
So affected paper book also submitted.
Paper book also submitted.
Submitted.
So what do you want now? What is the application for? Oh, the appeal itself is there.
It is for the enhancement of the amount.
Can't hear the appeal.
Insurance company also not present.
Yes. I'll put the liability on the insurance company, not on myself. Although the appellant is represented through counsel, none appears for the respondents at the time of call. Accordingly, let the matter stand adjourned till the next circuit. And the owner has been served. Is it required?
Owner is not required. Item
number 14 and 15.
I am for the petition. 14 is the appeal filed by the claimant, 15 is appeal filed by the insurance company. But in 15, there's a direction to file paper book. Till that is not filed.
There one.
There one.
Lordship, praying for time because paper book has been not yet.
How long? Tell us.
Next circuit.
No. How long? I'll give you 2 weeks time to file the paper.
Lordship.
On the prayer of learned counsel you are for the insurance company.
Yes.
On the prayer of learned counsel for the insurance company, the time for filing paper books is extended for a fortnight from date. Full stop. The matter shall be listed before the appropriate bench in the next circuit. Advance copies of the paper books shall be handed over to the learned advocate for the. You are for the claimants, must be.
My lord, I am for the claimant.
For the claimants.
Great.
Great.
Extremely.
Item number 16 with 17. My lord, I'm appearing on behalf of the claimant. My lord, I'm praying for next circuit.
On the prayer of the appellant, let the matter stand adjourned. Claimant is the appellant.
I'm the claimant, the appellant. Actually, there are two matters which are
On the
tagged
prayer of
together.
learned understood. On the prayer of learned counsel for the claimant, let the matter stand adjourned till the next circuit. Yes.
My lord.
Thank you.
Item number 18.
Second appeal hearing. Next circuit. Second appeal hearing, how can I finish?
Lordship,
Initially, this is the matter where initially I thought it was easy, but then you created the complications. Yes. Come back in the next.
grateful, Lordship.
Since this is the penultimate date of this circuit, the hearing cannot be concluded. So accordingly, let the matter stand over till the next circuit.
Grateful.
I've taken it on myself, no difficulty. Yes. Next.
Tomorrow, your lordship take up the entire list or it will be.
Tomorrow there won't be any entire list. I'll keep only a few matters. Out of those, 2 will be for judgment.
Great. Item number 19.
কতগুলো কেউ অ্যাপিয়ার করছে না, জাস্ট একটা করে লাইন অ্যাড করে দিই। None appears for the parties. Let the matter stand adjourned till the next circuit.
20,
Same.
21,
Same.
22,
Same.
23,
একই করে দিন।
24.
24 I am for the petition.
Yes, this is appearing for the first time.
No, my lord, second, my lord.
You have served on the other side?
Yes, sorry, my lord.
No, no,
The
no. You have
dispute
served
has
on
been
the other
resolved,
side?
my lord.
Huh?
Dispute has been resolved.
Oh, resolved, that's very good.
Yes, my lord.
Item
So matter
24.
become infructuous,
Very
my
good.
lord.
Learned counsel for the petitioner submits that the dispute between the parties has been resolved in the meantime. Puts up accordingly on the submission of learned counsel for the petitioner. CPN 61.
Yes, my lord.
CPN 61 of 2022 is disposed of as infructuous without any orders to cost. Thank you. Thank you.
25,
ওই না না পেয়েছো এটা নেক্সট সার্কিট
26,
সেম
27,
ওদের ডেকে নিতে হবে সাজান ওদের ডেকে ইয়েস সেম আপনি একবার তাহলে তো সবই নেমে গেল আর নতুন ম্যাটার ঢোকাবেন না আর যাতে একটা থাকলে একটা থাকবে হ্যাঁ দুটো নিয়েই আসুন একটা দুটো ম্যাটার তো থাকবে বোধহয় হ্যাঁ দুটো নিয়েই আমার কাছে তাহলে যখন পারবেন চলে আসুন থ্যাংক ইউ